Aloha mai kako, good morning. This is the August 13th, 2020 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other individuals of the public via the Zoom internet conferencing program. We're doing this in order to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are viewing the meeting via the Zoom webinar platform. For all meeting participants, I would like to stress to everyone the importance of speaking slowly, clearly, and directly into your microphone. And that also before speaking, you please state your name and identify yourself for the record. Please also be aware for all meeting participants, you are being recorded on the digital record of this Zoom meeting. Your continued participation is your implied consent to be part of the public record for the event. If you do not wish to be part of the public record, you should exit the meeting now. This Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our personal digital devices. Please note that due to matters entirely outside of our control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know and be patient as we try to restore the audio-visual signals to effectively conduct our business during the pandemic. My name is Jonathan Likeke Scheuer. I currently serve as the LUC chair. Along with me, Commissioners Axon, Chang, Okuda, and Wong, the LUC Executive Officer Daniel Ordenker, LUC Chief Planner Scott Derrickson, Chief Clerk Riley Hakoda, our Deputy Attorney General Cindy Young, and our court reporter Jean McManus is on Oahu. Our Hawaii Island Commissioner Cabral is unable to attend the meeting and may join us later. Commissioner Ohigashi is on Maui, and Commissioner Giovanni is on Kauai. We currently have 8 seated commissioners of a possible 9 and 7 attending this meeting. Our next agenda items are the continued proceedings on the Consolidated Declaratory Orders DR 2069 County of Hawaii and DR 2070 ROSEHILL et al. Will the petitioning parties for the dockets please identify yourselves for the record and remember to unmute yourself.
Good morning, John Mukai, Deputy Corporation Counsel on behalf of the County of Hawaii. Also present is Deputy Corporation Counsel Diana Melvin Lacey and Michael Yee, Director, and Deputy Director April Supranat.
Good morning, Mr. Mukai. Thank you.
Good morning, Chair, Commissioners, and everyone. Cal Chip Chase and Chris Gooden for the ROSEHILL petitioners.
Thank you very much, Cal. Let me now update the record. At previous meetings on this matter on June 25th, 2020, the Commission took public testimony and heard initial arguments from the petitioners. The Commission requested further information from the parties, and on July 23rd, Petitioner County of Hawaii presented and concluded its additional arguments to the case. Petitioner ROSEHILL et al. Was then instructed to present its case at this meeting due to time constraints. On August 4th, the Commission mailed our August 12th and 13th, 2020 notice of agenda to the parties, as well as to our statewide Oahu and Hawaii regular and email mailing lists. On August 10th, 2020, the Commission received Petitioner ROSEHILL's response in docket number DR 2070 to the County of Hawaii's argument during the meeting on July 24th, 2020, as well as the County of Hawaii's second supplemental submission. Yesterday, or 2 days ago on August 11th, the Commission received the petitioners in docket number DR 2070's response to the County of Hawaii's second supplemental submission filed on August 10th. Before we begin, I'd also like to take a moment to explain once again what these proceedings are about and how certain things have to be handled to ensure we are in compliance with subchapters 5 and 14 of our rules, as well as all of the relevant statutory requirements with regards to public meetings. We need to keep in mind that this is a request for a declaratory ruling. That means the Commission is being asked to interpret a statute, rule, or document and not make a determination on a factual dispute. While certain facts may be important in making an interpretation of law, in this type of proceeding, the facts really are not in dispute. The Commission is taking the basic facts as undisputed. What we are here to decide is the very limited issues presented by the petitioner, County of Hawaii, and the petitioner, ROSEHILL et al. Therefore, this is not, nor can it be, a contested case hearing where evidence is presented with witnesses and cross-examination. I would remind everyone of that fact. Again, the facts are not in dispute. It is about the application of law to accepted facts that we're hearing today. I'd like to impress upon everyone that under Chapter 14 of our rules, the only true parties to these proceedings are the declarants or petitioners, the County of Hawaii and ROSEHILL et al. Everyone else, including the Office of Planning, are in effect public witnesses. As mentioned earlier, public testimony for this docket concluded on June 25th. The County of Hawaii provided additional information on the 23rd of July, and the petitioner ROSEHILL et al. Will present today. So now I'll review our procedures for today. I will first recognize any written testimony that has been submitted in this matter. I will read those out for the commission, and they have been posted to our website. The representatives for ROSEHILL et al. Will be then given as much time as they reasonably need to complete their case. After that, the commissioners will be provided the opportunity, the petitioners will be provided the opportunity for final arguments, and the commissioners will be given the opportunity to ask questions of the petitioners or anyone who has testified and is available. Upon completion of the testimony and questions, the commission will come to a decision. Is there any questions from the parties, the declarants, on our procedures for today? Mr.
No,
Mukai,
Chair.
Mr. Chip.
No, Chair.
Thank
This
you
is
very
John
much.
Mukai. No.
Thank you. I will also note for the parties and the public that from time to time, approximately once per hour, I will call for 10-minute breaks. I will now recognize the written testimony that has been received on this matter. On July 6th, we received written public testimony from Linda Voloshin Spencer. On July 28th, from Mark Gordon. On July 31st, from Dana Heltz. On August 6th, from Steve Lopez. On August 10th, from the County of Kauai. And on August 10th, also from the County of Maui. Mr. Clerk, has any other written testimony been received by the commission?
Mr. Chair, this is Riley. No further testimony has been received to my knowledge.
Great. Okay. Cal, it's your floor. Can you give us a sense of how long you intend to take?
Yes,
before you
Chair.
begin?
Thank you. It should be under 30 minutes.
Okay. Please proceed.
Thank you, Chair. I have, as we did the last time and as we usually do, a screen to share with you. And so we'll put that up now. There we go. And while it's challenging to not be before you in person, I do appreciate that we can still have this kind of dialogue where we can at least look face to face, and you can look at the slides that we put up on the screen. We mean them to be helpful, and I hope that they are. As the chair mentioned, we're here for the continued hearing or continued meeting on the petitions. And at the end of the meeting on, oh, Chris is telling me to hold on. Can we just pause? Chris, Chair, Mr. Gooden has asked me to just pause for one moment.
Oh, you listened to Mr. Gooden?
I believe at a prior hearing, Chair, you ordered me to be nice to him.
I did, and that was a binding order.
I have faithfully obeyed it.
Can we just take a 3-minute recess?
Oh, my sincere apologies. Chris has asked us if we can take a 3-minute break. Apparently there's trouble putting it up on the screen.
3-minute break, or the chair.
Thank you, Chair.
Okay.
What's the matter there, big guy?
It is.
Jonathan, the order
Yes.
should have been binding and
Anybody who's provided testimony to us, including the Office of Planning at that time. If you have any further questions about that, you should contact our staff. Is that helpful, Scott?
I think so. They still have their hands raised, but they may just not be pulling down their hands.
Okay.
Thank you.
Are you ready, Mr. Chip Chase?
Very nearly, Chair. I think Chris is just about 30 seconds short of figuring it out. Chair, we've solved our technical difficulties. He's putting our slides back up on the screen. All right. There we go. I appreciate everyone's patience. And
Okay, let me just call us back in.
Oh, very good.
Okay, we're back on the record.
Thank you, Chair. And I appreciate the recess and I appreciate everyone's patience. Technology is awesome, except when it isn't. As I was saying, we're here for the continued meetings on the petitions. And this is the third time we've had an opportunity to speak with each other. The commission held meetings on the 25th and on the 25th of June and on July 23rd. And at the end of the meeting on June 25th, the commission asked the parties for a number of things. One of those things was Commissioner Okuda proposed that the parties submit findings of fact and conclusions of law to provide a structure for the commission's decision on these petitions. Commissioner Ohigashi invited the parties to submit briefing on any matter that they selected, and Commissioner Chang asked for a copy of the law at issue. As you heard from the chair, you're to consider a particular statute. Commissioner Chang asked for that statute, that's Chapter 205, as it existed or as it was in effect on June 4th, 1976. We provided all of those things. We provided findings of fact and conclusions of law that we believe provide an appropriate structure for the commission's decision. We provided briefing on additional issues following the June 25th hearing, and we provided a copy of the statute. We also, as the chair read out, had an opportunity to respond to the county's comments on July 23rd and respond to the additional briefing filed by both the county and the Office of Planning. So although in that 2-month time we've met and we've had an opportunity to submit additional written materials, this is the first opportunity that we've had to talk, and you've had an opportunity to ask me questions since our meeting on June 25th. And since it has been almost a couple of months since we spoke, what I wanted to do today is to begin by taking us back to the basics, not to repeat what we testified to or what's in our papers, but to bring us back to why we're here and what these petitions are really about. I'd also like to talk about some of the important takeaways, what we see as the important takeaways from the June 25th and the July 23rd meetings. And then I will frame your decision through our slides and my comments with you today around our findings and conclusions that we've submitted. So if you notice in the materials, an FOF or a COL reference on the screen, that relates to a particular finding of fact or particular conclusion of law that we've presented in our papers. And then finally, I want to talk about your decision today, but not only the actual decision, the effect of granting one or both or either, I would say, petitions that are before you. So the most basic thing is the chair has mentioned in these meetings now is we're here on a petition for declaratory ruling. That's the decision you have to make. And under those rules, under the commission's rules, a petition for declaratory ruling provides that on petition of any interested person, the commission may issue a declaratory order as the applicability of any statutory provision or of any rule or order of the commission to a specific factual situation. So under this rule, the starting point is always the petitions themselves. What have the petitioners asked the commission to do, asked the commission to rule on? And here, as the chair noted, there are only 2 petitioners, the County of Hawaii and my clients, the Rosehill petitioners. And so that's where we start. From there, we look at what the agreed facts are, as the chair said, the stipulated facts, the facts that are not in dispute, and then what is the applicable law. As we consider those things, I wanted to take a step back and talk a little bit about how we got here, why the county and my clients, the Rosehill petitioners, are actually before the Land Use Commission on these petitions. The idea for these petitions arose in discussions with the county's prior council. So we were in proceedings before the Hawaii Planning Commission, and in dialogue with the county's former corporation counsel, the deputy who was representing the county in this matter, he mentioned that he intended to petition the LUC for a declaratory ruling as to what he perceives or may be a conflict between the definition of short-term vacation rental in the county code and Chapter 205. We discussed that, and I said that I'd also considered petitioning the Commission for declaratory order on the same issue, determining whether the Chapter 205 as of June 4th, 1976, prohibited the use that the county has now regulated through its definition.
Cal,
And we talked about,
can I ask you to just speak slightly louder and slightly slower, or slightly closer to your microphone and slightly slower?
I will try to do both, Chair.
Thank you. This is an unusual thing for technology because I don't think anyone in your entire life has ever said, Cal, please project more.
That is actually true. And if I may digress for a moment, usually when I'm home, my 17-year-old daughter will shut the window that's closest to our neighbor's house because she feels like I speak too loudly and that the neighbors can hear our entire conversation. So that is a new one for me, Chair, but I appreciate the interruption. And if any commissioner or any person on the commission or the other parties can't hear me, please do interrupt, because I don't want to have anything lost or in any way confuse anyone. But as I was saying, Chair and members, as we talked about this, the Corp Council and I, we specifically discussed what facts should be presented to the commission, whether it was necessary to present issues related to any particular property or any particular use. And we both agreed that it was not, that we were here really just having the commission apply its law, Chapter 205, to the county code, and that the county code was the fact, the specific elements of the definition of short-term vacation rental are the facts, and that there was no need for any particular information about any particular properties, because that's not why we're here. We're not here on a contested case. We're not here on an enforcement matter. We're here asking the commission to interpret its law and apply it to the very specific facts of the county's definition. And so when you look at the petitions, that's exactly what the parties actually did. Here I've put up the county's petition, and the county in its petition asks for a declaratory order that farm dwellings may not be used as short-term vacation rentals pursuant to HRS sections 205-2 and 205-4.5 and HAR section 15-15-25 because the respective definitions and uses for farm dwellings and short-term vacation rentals irreconcilably conflict. And so the county's petition did exactly what the county's council and I discussed the county's petition would do, namely ask the chair, or namely ask the commission to compare these definitions and determine whether the definitions, definition of farm dwelling, definition of short-term vacation rental, irreconcilably conflict. That's exactly what we did too. We did exactly what we said we would do when I was speaking with the county's council. We petitioned, or we framed our question as of June 4th, 1976, the plain language of Chapter 205 did not dictate how long a farm dwelling must be rented in order to qualify as a farm dwelling. So we focused on the very specific element of the county's definition that we believe is actually at issue, duration, how long the farm dwelling may be rented, and asked the commission to rule on that specific issue. When OP filed its initial papers, it took exactly the same approach as both petitioners have taken. So I put OP's statement to you, or a testimony to you up on the screen. And in that testimony, OP explained that you need to evaluate both definitions and determine whether there is a conflict, as the OP puts it, i.e., that a farm dwelling may be rented for 30 days or less, focusing specifically on duration, which is what we have specifically focused on, focusing specifically on the definitions, not labels, not generalities, but the definitions, which is exactly what both parties have pointed you to. And all of that is important because, as the chair has said now, each time that we've met on these petitions, we're here on a petition for declaratory ruling, and that means that the commission is applying the law to undisputed facts. The commission is not in a contested case where it makes factual determinations or where it reaches outside beyond what the written petitions have placed before the commission. The undisputed facts here, the undisputed facts before the commission, are simply the specific definition of short-term vacation rental in the county code, what those elements are. And I took the time to go back to that because what I have seen since those initial filings and since that initial meeting on June 25th is a lot of misdirection from the county and to an extent from OP as well. Both OP and the county have since then tried to make this proceeding about many things that it is not. They've talked about the specific uses of petitioners' lots. They've talked about whether petitioners' lots were always legal. They've talked about whether there's any farming activity going on petitioners' lots. They've talked about not definitions, but terms in general, declaring broadly to whatever it might mean that short-term vacation rental uses are inconsistent with the ag district. The petitions before you are not about any of those things. The petitions before you are about exactly what the petitioners presented to you in their petitions. Does this definition, the county's definition, conflict with this definition, the state definition of farm dwelling as of June 4th, 1976? All that matters is that undisputed fact, the fact of the county's definition. And so we've put that back up on the screen. As I say, this is what the petitioners have actually put before the commission. No other facts, no other issues, no other matters. As the county phrases it, do these definitions conflict? As we phrased it, did Chapter 205 regulate the duration of any rental of a farm dwelling as of June 4th, 1976? That is all that is before the commission. And as I said, we have presented it exactly as OP has presented it to you. Everything else you heard about everything else after June 25th at the prior meeting on July 23rd and in the subsequent papers does not matter. None of that is before the commission, and none of that is before the commission because I and the prior counsel for the county specifically agreed on what we would present to the commission for decision. So those are the facts. The undisputed fact is the county's definition of short-term vacation rental. That brings us to the law that you apply to that sole undisputed fact, and that is the statutory provision in HRS Chapter 205 as of June 4th, 1976, and specifically the definition of farm dwelling. We have focused on, and the commission needs to focus on, that date because that is the date that the county picked. The county picked June 4th, 1976 as its regulatory date. According to the county's belief, rentals of less than 31 days in the ag district are fine, they're okay, if the lot was created before June 4th, 1976. According to the county's belief and the reason it framed its ordinance the way it did, rentals of less than 31 days in the ag district are illegal if the lot was created after June 4th, 1976. That is everything. It all comes down to that date. Was the lot created before or after June 4th, 1976? And is the rental more or less than 31 days? Nothing else matters in the county's regulation. So we have the statutory definition a farm dwelling as of June 4th, 1976, applied to the factual elements of the definition of short-term vacation rental found in the county code, ordinance 2018-114, and the question presented by the petitions in different forms, but it's the same question. Do these conflict? Can you have a farm dwelling rented for less than 31 days? That's it. That's everything. What this is not about is farming. Nothing in the county code deals with the use of the property or with who is using the property. And so we've put up on the screen a couple of those points. It is quite clear from the testimony that has been given under oath by the county that the county is not regulating to ensure that dwellings are used in connection with a farm or that the occupants receive income from agricultural activity. The county specifically told you on June 25th, quote, "There's nothing that disallows a person from simply having a residence on an agricultural zone property." In colloquies with Commissioners Chang and Okuda in particular, the county made very clear that even if you came to the county and said, "I will never do agriculture on my property," the county would still consider your dwelling to be a farm dwelling. In the July 23rd hearing, the county went even farther in response to questioning and said, even if you come in and tell me I'm going to build a McMansion and there will never be farming on my lot, the county will still consider it a farm dwelling. That is the county's petition. Nothing before you in the county's code or the questions on these petitions have anything at all to do with farming or the use of the property or who is occupying the property. By the same token, these petitions and the county code are not about vacationers or vacationing. As the county made very clear in its testimony to you, renting a farm dwelling located on state agricultural or within the state agricultural district for residential or vacation purposes is fine as long as the rental is 31 days or more. By their definition, as we put up on the screen, it is not a short-term vacation rental as long as it's for 31 days or more. Who is using it, why it's being used, entirely irrelevant to the county. The only thing that matters is that number, 31 days. At the same time, and for the same reason, in colloquy with Commissioner Wong at the June 25th meeting, the county made clear that even if the tenant, the person renting the farm dwelling, was a farmer who was going to farm the property, that rental would be illegal, would be considered a short-term vacation rental, even though it's a farmer who's farming the property, if the tenancy, the rental period, is less than 31 days. So as we put up on the screen, that colloquy shows in the example, the farmer is clearly using the dwelling in connection with the farm, but it doesn't matter to the county. The guy who comes on to grow papayas is out of luck. It's an illegal use if his tenancy is month to month, if it's less than 31 days. And so the papaya farmer is out of luck, and Commissioner Wong, as it was his example, is never going to get his papayas unless the guy rents for 31 days or more. Everything comes down to that number, absolutely everything. And so we put up on the screen a table showing different scenarios. And as you can see, as you go through the table, the use does not matter to the county. The use does not determine legality. The use does not control at all in the county's mind. Everything comes down to duration. Nothing but duration matters. A rental for any reason of 31 days or more, residential, vacation, farming, whatever, is fine. A rental of less than 31 days for farming or any other purpose is illegal. That's all that matters to the county. This fact was made abundantly clear in colloquy between Commissioner Chang and Director Yi. In that colloquy, Director Yi made clear that the only fact that makes a short-term vacation rental, the deciding factor, is it's less than 31 days. That's it. How the property is used does not factor into the analysis at all. 31 days or more is fine. Less than 31 days is not fine. So since the only question, the only issue is duration under the county code, the only thing the commission needs to answer is whether a farm dwelling can be rented for 31 days or less and still be a farm dwelling. I'll say that again. The only thing the commission needs to answer is whether a farm dwelling may be rented for less than 31 days and still be a farm dwelling. These proceedings, commissioners, have already answered that question. During the hearing before the commission, the county expressly conceded there's no prohibition on farm dwellings being rented for 30 days or less. That's everything. The county has conceded the only issue before you. OP has said the same thing. In testimony on June 25th, 2020, OP said, and I'll quote, "A renter for 30 days or less that farms the land may be allowed under the definition of farm dwelling." That's the only issue. If you can rent a farm dwelling for less than 31 days on a month-to-month or whatever term that our landlord-tenant code would allow and still be a farm dwelling, that resolves the entire disputed issue. There is no other issue before the commission because there is no other issue in those undisputed facts, the undisputed facts of the county code. This was made clear in OP's supplemental response as well. So a farm dwelling can be rented for less than 31 days and it is still a farm dwelling. The county and OP have conceded this point, I assume for lots of reasons, but including among them that the statute is perfectly clear. So the law that we apply is Chapter 205 as of June 4th, 1976. Let's walk through that statute. Section 205-2, discussing districting and classification of lands, is a general use provision. It generally lists the uses that are allowed in the ag district, including farming, as well as accessory uses such as dwellings. There's nothing in that general use provision about the duration of rentals of farm dwellings. It simply allows them as a general matter. Section 205-4.5 deals with the specific permissible uses within the ag district. So we go from the general in 205-2, it's like a funnel. We narrow that down to the specific, and the specific is 205-4.5. And under 205-4.5, farm dwellings are a specifically allowed use. If we keep moving along that funnel, the general of 205-2 to the more specific of 205-4.5 to the very specific, it's the definition of farm dwelling. What does that mean? Under the definition of farm dwelling in Chapter 205 as of June 4th, 1976, farm dwelling is, farm dwelling as used herein shall mean a single family dwelling located on and used in connection with a farm or where agricultural activity provides income to the family occupying the dwelling. There are two clauses in that. The dwelling is either used in connection with the farm or the family receives income from agricultural activity. Neither clause concerns the duration of any rental. So that's our law. Set out the law. We turn to applying it to the specific facts, those things that the commission will do when it writes its decision. The county's definition has three specific factual elements. The first element is that the dwelling is one in which the owner or operator does not reside on the building site. The owner doesn't live there. Element 2 is that the dwelling has no more than 5 bedrooms. There's a cap on the number of bedrooms in the county's definition. Element 3, we come to what's really at issue, is the dwelling is rented for periods of 30 consecutive days or less. It is rented for less than 31 days. That's it. There's nothing in there about who is occupying the dwelling. A transient, a vacationer, a farmer, and there's nothing about how the dwelling is used. Residential, vacation, farming purposes, in connection with the farm, consistent with Chapter 205. Nothing in the elements of the county's definition addresses any of those things. So we apply the law to the actual elements, the only facts that are before the commission. Element 1, the owner doesn't reside on the dwelling site. We apply that or look at that through the lens of Chapter 205. Nothing in the definition of farm dwelling requires the owner to reside on the building site. He does not have to live there. It can still be a farm dwelling, even if the owner rents it out or does not otherwise live there. And so the county has conceded this specific point, as we put up on the screen in testimony before the commission on June 25th. The county specifically agreed that the owner of a farm dwelling does not need to reside in the farm dwelling. It's still a farm dwelling, even if the owner doesn't live there. And that fact is specifically contemplated by statute. Chapter 205 specifically contemplates that a farm dwelling may be leased. So we turn to the second element. The farm dwelling under the county code, or the dwelling, I should say, has no more than 5 bedrooms. That's the county's factual requirement. We apply the code, or we apply Chapter 205, I should say, to that specific factual element, and we see that nothing in the definition of farm dwelling or anywhere else in Chapter 205 regulates how many bedrooms a farm dwelling has. There's no minimum, there's no maximum. It could be 1 to 1,000 in theory under the Chapter 205. It's simply not addressed, and no party has argued otherwise. So then we come to the one element of the county code that has been discussed in detail in these proceedings. The third element of the county code, the third thing that makes any dwelling a short-term vacation rental, is that it is rented for a period of 30 consecutive days or less. We apply Chapter 205 as of June 4th, 1976 to that element. And we see that nothing in the definition of farm dwelling regulates how long the farm dwelling may be rented. It does not set a minimum rental period. It just isn't there. The language of the statute is plain. It does not prohibit rentals of 31 days, less than 31 days. You can rent a dwelling on a farm dwelling on a month-to-month lease or for a period of less than 31 days, and it is still a farm dwelling. And again, that is all you're being asked to declare on these petitions. So let's talk about the consequences of, if I may pause in my presentation, I was told on the screen that my internet connection is unstable. So if I seem unstable to you, please let me know. The county's petition, granting the county's petition, would mean that a farm dwelling cannot be rented for less than 31 days. That is the effect of granting the county's petition, because that is how the county has defined short-term rental. And the only thing before the commission is the county's definition. With respect, you cannot make that declaration because it is utterly inconsistent with Chapter 205, and because every party before you, plus OP, have said that the code, the Chapter 205, does not prohibit rentals of less than 31 days. So everyone before you have said that no, Chapter 205 does not prohibit the thing that the county has prohibited. And it's plain under the law that in fact, Chapter 205 does not prohibit rentals of less than 31 days. So we put our table back up on the screen. This is the effect of granting the county's petition. This is the outcome that the county has urged you to reach despite its concession, that we have now converted what we care about under Chapter 205 from the actual definition that's used in connection with the farm, or that the family who occupies the dwelling receives income from agricultural activities, to a durational test. Is it more or less than 31 days? You've also set a statewide rule based on a specific county's code. As we talked about in our briefing, and as we talked about in our meeting on June 25th, short term does not have a fixed meaning in this state. The county defines short term as less than 31 days. Honolulu defines short term as less than 30 days. Hawaii, it's less than 180 days. And on Maui, it's 179 days or less. The other counties, in particular Maui, also specifically define transient, something Hawaii County Code does not do. And so you'd be setting a statewide rule, even though each county has approached this issue differently, and in some cases, in particular Kauai County, very surgically looking at the particular uses on the property to determine whether they comply with Chapter 205. Hawaii County has approached it with a blunderbuss, just a hammer saying 31 days, okay, we don't care about anything else. Less than 31 days, not okay, and we don't care about anything else. It would be improper to set a statewide rule based on one county's very blunt approach to this issue. So then what happens if you grant our petition? The only thing you would say is the thing that every party before you plus OP have already conceded, have already told you, that as of June 4th, 1976, the plain language of Chapter 205 did not dictate how long a farm dwelling must be rented in order to qualify as a farm dwelling. That is as far as your ruling would go. It does not approve vacation rentals, whatever that may mean to whatever particular county. It does not approve short-term rentals, whatever that may mean to whatever particular county. You're not approving vacation uses in general. You're not approving any use of any particular property. None of that is before you. You're simply declaring what is indisputably the law and what every party plus OP before you have said is the law. From there, it is a question of enforcement. It is a question of actually looking at the uses to determine whether they meet the definition in Chapter 205 of a farm dwelling. If you look at Kauai's testimony, that is the approach that Kauai takes. That is what you do. You look at it on a case-by-case, use-by-use basis, and it is an enforcement matter. So similar to Kauai, the county, rather than its blunt instrument that frankly violates the landlord-tenant code because it prohibits a farmer from having a month-to-month lease, rather than that blunt instrument, would have to actually do enforcement, would have to actually determine whether a dwelling is being used in connection with a farm or whether agricultural activity provides income to the family who occupies the dwelling. That's the consequence. We can't depart from the statute, Chapter 205, as of June 4th, 1976. We can't depart from the facts before the commission, simply the county code, 2018-114. Looking at that law, looking at the code, and under the testimony that you have already received from the county and from OP, the only outcome is that the Rosehill petition should be granted and the county's petition should be denied. Thank you, commissioners.
Thank you very much, Cal. Are there questions for Mr. Chipchase from the commissioners? Commissioner Okuda, followed by Commissioner Wong.
Thank you, Mr. Chair. Thank you, Mr. Chip Chase, for your presentation. Can I ask you this first question? And this deals with our administrative rule that deals with when we may issue a declaratory ruling, and that's HAR section 15-15-98, parent small a, close parent. And that says, on petition of any interested person, the commission may issue a declaratory order as to the applicability of any statutory provision or of any rule or order of the commission to a specific factual situation. I think you also quoted that in one of your slides that you shared with us. Did I accurately state that provision of the administrative rules?
Commissioner, you broke up at the end, had that technology-induced metallic voice, but I think I understand your question. And if I understand the question correctly, it's you correctly quoted the rule, Commissioner.
Okay. Would we be clearly erroneous, or well, let me back up a bit. Is the standard about whether or not we have to issue or not issue a declaratory order, is that an abuse of discretion standard on appeal? In other words, we might think that you might have a good point, but we're going to exercise our discretion, you know, based on good cause in the record and not issue, you know, a declaratory order. Would the standard on appeal to decide, or where the appellate court would decide whether we're correct or not, would that be under what's considered an abuse of discretion standard?
And so I do believe that may, as used in the context of this rule, is permissive rather than a mandatory declaration. Sometimes may can be mandatory. I don't believe that that's an appropriate construction of that rule. So to that extent, I agree with you. I don't know that I would see it as an abuse of discretion standard. It would have elements of that. I believe it's an arbitrary capricious standard would be the correct standard to apply to that. And I would go further and say that when the law is clear, it's always arbitrary and capricious, or to use your phrase, an abuse of discretion, not to answer the petition. In other words, I agree with you that there is discretion, but that discretion is not unlimited. And where the law is clear, I do not believe that discretion can be properly exercised to refuse to rule on the petition.
Now, I understand that your assertion that you and the county have stipulated to the presentation of certain things to be considered the factual basis. But is it within the Land Use Commission's discretion to decide that no, there's actually possibly more potential facts which would probably educate us better in making a decision, but since these additional facts or situations have not been presented to us, we would exercise our discretion and not make a decision at this time? Would that be a proper approach?
No, Commissioner, I do not believe that would be a proper approach. As the chair instructed at the beginning of each of these meetings, and is I think clear from the concept of a declaratory order, you are only looking at the stipulated facts, essentially the facts that have been presented to you, rather than reaching beyond the petitions. And if the parties to these petitions agree on those facts, we agree that this is the code, and we do, and we agree that that's the factual basis that we request your ruling, and we do, and you're to make a determination based on the stipulated facts, and you are, then I believe that it would be an abuse of discretion, or in your phraseology, arbitrary, I'm sorry, your phraseology was abuse of discretion, mine is arbitrary and capricious. I do believe it would violate that standard if you declared or you refused to rule on the basis that there might be, or that there are some other extraneous facts that are not presented in the petitions. The facts that are presented in the petitions go directly to the questions that you've been asked to answer. And so since the facts that have been presented, the county code, specifically and completely relate to the narrow question before you, I don't believe it would be appropriate to refuse to rule on the petitions because there might be some other extraneous facts out there. We've stipulated to them, and they are the only facts that go to the narrow question you've been asked to rule on.
But isn't it true that the Land Use Commission retains the discretion to decide that a party or parties that are requesting a declaratory order have not met their burden to present the specific factual situation, as that term is used in HAR section 15-15-98, parent small a, close parent, that we could in our judgment make a determination that the petitioners have not met their burden to present the specific factual situation required by the rule?
As an abstract matter, Commissioner, I would agree with you. In the abstract, that is a possible scenario. In this specific scenario, I don't believe it's a possible outcome because the facts that have been presented to you are the only ones relevant to the question. So if you had a question before you that required other factual information, possibly. But the questions before you, whether phrased by the county or phrased by my clients, the Rosehill petitioners, do not require any other facts. They only require the county code, and the county code, the terms of it, the substance of it, have been stipulated to and presented equally in the same way by both parties. So where all of the facts before you are all of the facts that you need to answer the only questions before you, it would not be an appropriate exercise of the Commission's discretion to say, well, we need additional facts also, even though they won't relate to or could not relate to the question you've been asked to answer.
Okay, I hear and I understand your argument. Let me ask a slightly different question. Is it true or not true that if a question being presented is speculative, that the Commission would have discretion to deny the petition or deny the request for a declaratory order?
I'm just going to interject very briefly before you answer, noting that Commissioner Cabral has joined the meeting.
And so, Commissioner, my answer will be unsatisfactory, but I like the colloquy. And if you could help me understand what you mean by speculative, I might be able to give you a better answer. Is I would understand that and certainly invite and want more dialogue on this topic. As I would understand speculative, there's something uncertain, unclear about the facts that have been presented to you or the question you've been asked to answer. It's a hypothetical, I suppose, is how I would see it. And if the question were purely hypothetical, maybe there would be some discretion to deny it. But that's not our case. Our case is entirely concrete. The county has adopted an ordinance. The terms of the ordinance are fixed and clear. Both parties have presented that ordinance to you, and both parties have presented the same question related to that ordinance, just phrased in different ways. We focused on duration, the county focused on the ordinance as a whole, but it's the same question. And so in this particular instance, since there is an existing law, since that law is in effect, and since the terms of that law are clear, the county code, there wouldn't be anything hypothetical or to put it as you have, speculative. But if I've misunderstood what you meant by speculative, I'd love the opportunity to continue the discussion.
Yeah, well, let me ask a follow-up question. Is it true or not true that the county ordinance as written might be considered valid in its application using your standards of validity if it was applied one way, for example, to allow, if it allowed persons who qualified for agricultural use to occupy the property, and perhaps a different approach or a different ruling if in fact the county denied persons who were engaged in agricultural use to occupy the property. What, for lack of a better term, let's call it for a short-term duration, using your description of the term. In other words, it's the application of the ordinance that determines, for lack of a better term, its legality or illegality.
That is a great question, and I think a great topic. I think it goes beyond what is actually before you, but I'd like to address it. So a statute or an ordinance, any law, can be invalid on its face or as applied. It doesn't have to only be in the application that the illegality arises. It can arise on its face. And there's many examples of that in our courts and in courts around the country, including the U.S. Supreme Court. So as a basic matter, a statute or an ordinance, a rule, any action of the government can be invalid on its face or in a particular application. As to whether the county might consider or might actually apply its ordinance uneven-handedly, in other words, not in the way written, so that it does end up making calls as to whether a particular use is consistent with 205 or a particular use is inconsistent with 205. That is what I would call a truly hypothetical or speculative issue, right? The county code is plain on its face, and it does not invite room for that kind of discretion. And so whether the county nevertheless wants to exercise that discretion is an entirely hypothetical matter. In my view, the county could not exercise that discretion because the county code is plain. So in attempting to exercise that discretion, the county would be violating its own ordinance. It would be engaging in an illegal activity. And I believe that that actually would go farther and would end up running afoul of the Equal Protection Clause, because you'd have selective enforcement issues associated with it. When the law is plain and the county chooses whom to apply it to, whom to apply the law, where to enforce it, you violate the equal protection. You have to enforce all laws even-handedly. And this law is plain on its face. It does not allow the county that kind of discretion. So with respect, my answer would be no.
Yeah, but isn't it true that the Land Use Commission is really a adjudicatory body of limited jurisdiction? In other words, one of the things that the Land Use Commission is not charged with is determinations of constitutionality or unconstitutionality, or to put it more bluntly, if that was really an issue, wouldn't a better place for you to bring that action and the court that would clearly have jurisdiction over it would be the federal district court?
You're absolutely correct with respect to the commission's limitations. I might not describe the commission as a purely adjudicatory body. I think it has other functions, but I would agree that it's not declaring county codes unconstitutional or constitutional. That's not your function, which is why exactly neither party has presented that question to the commission. You're not here to decide whether this is a valid or an invalid provision. You're not here to decide whether it's violates the US Constitution or any statutory provision. That's not what is before you in the least. Your call is simply, did Chapter 205, as of the date the county picked, regulate the minimum rental period of farm dwellings? That's it. That's as far as it goes. And the consequences from a constitutional, unconstitutional standpoint are in no way before the commission. That's not being presented to you or being asked of you by either party in any way or form.
Let me read you, and this is changing topic a bit. Let me read from you HAR section 15-15-100A1A, and I'll ask you after I read that section whether or not what I read was an accurate statement of that section and of the law.
Commissioner Okuda, if I may, before you continue, I'm just trying to manage the timing of the meeting. About after this question and Cal's response, how much more do you have, do you think?
2 more questions, maybe 10 minutes.
Okay. Would it be okay if we take a break now?
Yeah, this is an appropriate time, Chair.
Okay, it's 10:02. Let's reconvene at 10:12 a.m. We will continue with questioning from Commissioner Okuda, followed by Commissioners Wong and Chang. Okay, folks, it's about a minute. We ready to go? Mr. Okuda, will Commissioner Cabral be joining us?
Sending us.
Chair, I'm trying to establish communication with her.
Okay. Let's just go ahead. She can join if she can. I think because of having missed portions of the proceedings, her ability to deliberate might not exist, but I'll wait for guidance on that. So let's come back to order. And we were in a colloquy between Commissioner Okuda and Mr. Chip Chase. Mr. Okuda was going to cite some administrative rules and ask Mr. Chip Chase whether he had correctly stated the law.
Thank you, Mr. Chair. Mr. Chip Chase, let me quote from HAR section 15-15-100A1A. And after I quote that section, I will ask you whether I accurately stated that section and accurately stated the law. Section 15-15-100, consideration of petition for declaratory order, parent, small a, close parent. The commission, within 90 days after submission of a petition for declaratory order, shall, parent 1, close parent, deny the petition where, parent, capital A, close parent, the question is speculative or purely hypothetical and does not involve an existing situation or one which may reasonably be expected to occur in the near future. Did I accurately quote that section of the administrative rules?
Yes, Commissioner.
We touched on this at one of the earlier hearings, and just like you putting a reminder up by using the PowerPoint slides, I thought maybe I would ask this question again, just so that we have some context here. Is it true or not true that in Hawaii's land use system, the Land Use Commission makes certain decisions, but within, for example, the agricultural district, the counties have authority to basically issue their own regulations or zoning regulations or requirements?
To an extent and with lots of exceptions, I would say yes.
Let me quote you something from the case Save Sunset Beach Coalition versus City and County of Honolulu. That's 102 Hawaii Reports 465 at page 482. The Pacific Third citation is 78 Pacific Third, page 1 at page 18. And I'll ask you when I'm finished whether I accurately stated the law or the section from that case. Okay. In Hawaii's land use system, the legislature's statutory districts constitute more of a general scheme, and presumably by delegating authority to zone to the counties, the legislature intended that specific zoning be enacted at the county level. Did I accurately state the law? Did I accurately state the law?
I don't have that Obayashi case, I think is what you're quoting from. You're in and out. So I think you said Save Sunset Beach, which I always know is the Obayashi case. And I don't have it in front of me, so I couldn't tell you whether you quoted it correctly, but as a general proposition, that is a correct statement of the law.
So in other words, with respect to what takes place within the agricultural district, the County of Hawaii can make its own ordinances, provided that those ordinances do not conflict with state law, correct?
As a general proposition, that's true. I would say they can't conflict with a bunch of other things too, and there are other limitations on the county's powers. You know, Zoning Enabling Act is 46.4. That requires that all zoning be done pursuant to a comprehensive long-range plan and has a bunch of other requirements. So accepting that there are lots of exceptions to that statement, it is generally true.
What case or other legal authority can you point to which indicates that the Land Use Commission can override a legislative decision made by the Hawaii County Council as far as what type of rules, albeit might be more strict rules than the Land Use Commission has, with respect to protection of agricultural lands or agricultural uses? In other words, what authority can you point to us that shows that we as the Land Use Commission have the authority to override a legislative decision made by the County of Hawaii?
What I would say, Commissioner, is I'm not aware of any authority, and I didn't look for any because that's not what is before you. That's not what we've asked you to do. The county hasn't asked you to validate their ordinance on the other side of it, right? So neither party is asking the commission to weigh into that kind of question. Neither party is asking the commission to weigh into, can the county regulate ag land in this way? Neither party is asking the commission to declare ordinance 2018-114 good or bad, up or down, legal or illegal in any way. Neither party has presented those kinds of questions to the commission. So with respect, the law you've asked me to find, I have no idea because I have not looked for it. And I haven't looked for it because it has nothing to do with the issues that are before the commission on either petition.
But isn't it true that if we grant the relief that you are requesting by your petition, we in effect are at least partially overriding the decision of the County of Hawaii's County Council?
No, Commissioner. I would not say that's correct at all. All you're doing is applying the law to the specific factual situation that both sides, the county and we, have asked you to apply the law to. That it does not in any way override the county council. It doesn't invalidate the county council's ordinance. It simply answers the question that both parties have presented to you. Can you rent an ag dwelling for less than 31 days and it still be an ag dwelling? That's it. That's all either party in effect is asking you to declare. And that's as far as your decision goes.
What case authority can you point to, or statutory authority can you point to, which indicates that the county council could not draw what amounts to a bright line in the sand with respect to protection of agricultural uses? In other words, what authority indicates or shows that the county council, in exercising its legislative powers, could not simply say, look, we're going to make a bright line as far as protection of agricultural lands, and so we are going to just say that if a occupancy is less than a certain period of time, because that type of occupancy may be more likely than not to be non-agricultural use, we're just going to prohibit it.
And so if you'll allow me a little leeway, I'll answer your question first, but I think it dovetails into a couple of related points that follow from your premise. that I'd like to address. I would say quite simply, although this is not remotely the issue before the commission, and so I want to make that clear that no one is asking the commission to make this kind of declaration. It is not an issue before you in any way, or nor to determine the scope of the county's powers in any way. Those things are not before the commission. So I regard our discussion, our colloquy, as really an academic one, because it has nothing to do with the issues that are actually before you. But I would say, Commissioner, that the supremacy clause of the Hawaii Constitution makes very clear that although there is concurrent jurisdiction, as recognized in the Obayashi case, for the regulation of ag lands and lots of other things, ultimately state law controls. So if the county did something obvious, like say, you can't have farm dwellings, we declare there's no farm dwellings within the state agricultural district, flat out. Or we declare some other use that is expressly allowed by 205, like we declare you can't farm in the agricultural district. We just don't allow it. That would be wildly illegal. It would plainly violate the supremacy clause because the state has said this use is okay. And you can't simply declare a permissible use under state law impermissible under county law. Obayashi doesn't go that far. Obayashi recognizes that the more restrictive of the two control, but it does not address and could not address the situation where the county outlaws something that Chapter 205 expressly allows. That would violate the supremacy clause, and we could find a ton of cases on that. The related points that are sort of embedded in your premise are these. The first is that the county is doing anything protective of agricultural land. It flatly is not. That is not the purpose at all. It's not in the ordinance remotely. As we've gone through, it's simply a durational regulation. And it has the effect of declaring illegal a farmer farming on his land or a tenant farmer farming on someone else's land under a lease that is less than 31 days. That's not protective of agriculture. And the ordinance itself does not at all consider the use of the property or who is using the property. So maybe the county could do something protective of agricultural land. That is not what the county did. The second point that is embedded in your premise is the timing of that regulation. Could the county today say we adopt a law effective August 13th forward, regulating, prescribing, prohibiting a particular use in the agricultural district? Maybe, depending on what it's doing. That's definitely possible, that prospective regulation. What the county has done here is gone backwards and say any lot that was created a mere 43 years ago, 43 years before our effective date, prohibits a rental of less than 31 days. We're doing it retroactively. There's no grandfathering, there's no lawful non-conforming use. You couldn't have done it for 43 years before we told you you couldn't do it. That's entirely impermissible for a county to reach backwards in time and regulate in any circumstance. No body can do that. All laws operate prospectively. The putting that together and coming back to the question that is actually before the commission, that's why we focused on June 4th, 1976, because that's the county's regulation date. It isn't April 2019. Their regulation date is June 4th, 1976. So we focused on Chapter 205 as of that date. And we've come before the commission, both parties, using the narrow jurisdictional authority, narrow but real, right? And when you have jurisdiction, there's an obligation to exercise it. It's narrow, but it exists. The narrow jurisdictional authority to declare the application of the law, here Chapter 205, to a specific set of undisputed facts. Here, 2018-114 of the county code, county ordinance 2018-114. And the only question within that narrow set of law and facts is, did the law 205 as of June 4th, 1976 regulate or prohibit the rental of farm dwellings for less than 31 days? Nothing else in any way is before you. The county's authority, the validity of the ordinance, or any of those other questions. They aren't presented in the petitions, and they're not things that either party have asked the LUC to answer.
Not to belabor this point, but even though you state that it's not presented in the petition, isn't it true that all these other points are still directly related to the matters that you brought, or are issues that flow from this petition that you brought?
I would agree that some of them bear some relationship. I wouldn't agree all of them. There's a number that don't. For example, the county's power to regulate generally ag land is not related in any way to the petitions or to any issues that might flow. But as to those things that have some connection, and obviously there's some connection because both parties agreed to come before the commission on these petitions that look like the ones that were filed. So they recognize that the commission's input and role, its jurisdiction, has some relevance to the broader issues between the parties. No question. But that doesn't change the limited nature of the commission's jurisdiction or the limited nature of the question that has been presented to the commission, or finally, the effect of the commission's decision. It is simply declaring that the law did not regulate rentals of less than 31 days, and the decision itself goes no farther than that. And that decision is squarely within the commission's jurisdiction.
But if there are these other issues, which seem to be more than just potential issues, what legal prejudice would your client suffer if we exercise our discretion, not grant your petition, and simply leave it to you to bring this up either in the circuit court or in the federal district court? What's the legal prejudice to your client by leaving your client to deal with these, deal with these issues so that we don't have any piecemeal litigation or piecemeal decisions? That if you have this big beef it out at federal district court.
And so I appreciate that question too. And let me address it in a couple of ways. The first is that, the prejudice in a punt, I guess I would say, if you wanted to, pass on ruling on either petition, is embedded in the LUC's jurisdiction. You pointed us to 15-15-100. And as you quoted, it contains the word shall. So within X period of days, the commission shall do these things. One of the things that it can do, one of the options under shall, is to deny, or not grant rather. If I were to quote it, deny the petition, and you looked at subsection A, right? So if we look at the structure of that rule, we have a shall. You have to do one of the options set out before you. You don't have any other choice in the matter. One of the options is deny the petition. And the one you focused on is subsection capital A. And that gives you a specific basis on which you shall deny the petition, where it is purely hypothetical, is speculative or purely hypothetical, and so there's two parts to it, right? Speculative or hypothetical, and there's a conjunction there, so you have to meet that too. Does not involve an existing situation or one which may reasonably be expected to occur in the near future, right? So your ability to deny is expressly circumscribed, and in this example, by that text. You'd have to deny on that basis, those things would have to exist. It'd have to be speculative or purely hypothetical, and that second clause would need to be met. With respect, that is plainly not the situation here. There's nothing speculative or purely hypothetical at all, and that second clause doesn't exist. The situation is already on the ground. It is an existing situation, and so you can't meet that second clause. And so like any party coming before an agency that is tasked with having a jurisdictional obligation, responsibility, my clients are entitled to the exercise of the LUC's authority within the scope of its jurisdiction and not to have that jurisdiction punted or passed for any reason other than is expressly set out in the rules. And with respect, this situation is not one in which the rules allow the commission to pass on the exercise of jurisdiction. It does not meet those criteria for passing. And so I think when a party invests the time and the money pursuing a ruling that is squarely within the body's jurisdiction, and the body decides not to issue it for reasons that are not contained in its governing rules, that is prejudicial to them and to the efforts that they've invested. In terms of piecemeal litigation, I wouldn't qualify or describe this effort as that at all. Rather, it was an effort that both sides, both the county and my clients, thought was appropriate prior to engaging in further litigation, to have this one narrow question answered by the body that is tasked with answering this one narrow question.
Okay, I'm going to ask one final question regarding whether or not a statement made in an earlier declaratory order, which the Land Use Commission issued back in 1994. I know it seems like ancient history, but my question is going to be whether or not, notwithstanding the fact that the order was issued on a 1994 docket, whether or not you believe that that is still an accurate and valid statement of the law. But before I ask that question, let me just say something about punting, okay? And let me assure you, Mr. Chip Chase, I'm listening to what you're saying. I haven't made any decision up about anything on anything yet, okay? But I don't necessarily view respecting the legislative decisions of the county council of the county of Hawaii necessarily as something negative. In fact, I think many of us, and I know you're of the same mind, we all try to be very careful to be sure that we do not view legal proceedings as reflecting an entity called the state of Oahu, yeah. Sometimes those of us in Honolulu, we have to be careful not to think of Hawaii as the state of Oahu. But anyway, my final question is this, and let me quote from the declaratory order entered in this case in the matter of the petition of John, spelled John, Godfrey, Godfrey. That's docket number DR94-17. It's conclusion of law number 5, found at page 17. And it's that conclusion of law stated, and I quote, Chapter 205, Hawaii Revised Statutes, does not authorize residential dwellings as a permissible use within an agricultural use district unless the dwelling is related to an agricultural activity or is a, quote, farm dwelling, close quote. That's the quotation from conclusion of law number 5 at page 17 of that declaratory order. Do you believe that that is still an accurate statement of the law as of today?
Commissioner, through the magic of technology and the good work of Chris Gooden, I was able to read along with you. And so I believe that that is both an accurate statement of law and that you correctly quoted the conclusion of law. And I would add just into our colloquy about punting and respecting the authority of the county or the county legislature. I entirely agree with you. And so my point is simply that, as we've said, nothing in what either party, I mean, the county is before you asking for declaratory ruling too. And so it's difficult for the county to say, in my view, that this would be an inappropriate exercise of the LUC's authority when the county is asking you, coming before you, for a ruling on exactly the same issue. So the county is here with me saying, please rule on this issue. We just see the outcome differently, notwithstanding the county's admission. So I don't see any treading on the authorities of the counties, this county or any other county, by coming before the Land Use Commission. And as to punting, all I mean by that is that the are very narrow bases on which the LUC may decline to issue a ruling. And to the question of prejudice, we would view it as prejudicial if the LUC declined to rule on for any reason other than those stated in its rules.
Okay. Thank you, Mr. Chipchase. Thank you, Mr. Chair. I have no further questions.
Thank you very much, Commissioner Okuda. Commissioner Wong, followed by Commissioner Chang.
Thank you, Chair. Thank you, Mr. Chipchase. The question I have is, I'm just a simple guy, and, your long explanation and everything with Mr. Okuda was very eloquent at best, but very confusing to me. So can you say in one sentence, without commas, parentheses, anything, what are you asking for?
Whenever Commissioner Wong begins with, he's just a simple guy, I know I'm in trouble, because that is not true. And so I know something bad is coming at me, but that wasn't too bad. Commissioner Wong, all we're asking for is a declaration that as of June 4th, 1976, Chapter 205 did not prohibit renting a farm dwelling for less than 31 days.
Because, Mr. Chipchase, I want to thank you for that one sentence. I'm going to ask the same thing to the county. So I just wanted to make sure everyone is asking the same questions in my own ideas and thinking. So that's all. Thank you. Thank you, Chair.
You're welcome.
Thank you. Commissioner Chang.
Thank you, Mr. Chair. First of all, Mr. Chipchase, I always appreciate your zealous advocacy on behalf of your client. You are always prepared and are very responsive on your feet. So I appreciate that. My questions are going to be rather simple. Would you agree that the issue that the Land Use Commission, oops, did we lose him?
I'm here, Commissioner. Mr. Gooden, who I always am nice to, seems to have lost me, but I can see you.
We are still here. We're still going.
Okay. Something happened to my screen. All right. Let me just ask you this question then. That the issue before the Land Use Commission is the Land Use Commission's interpretation of Chapter 205. We're not, right? You would agree with that?
A specific portion of 205, yes.
Okay. And that if the county is preempted from adopting any rule or ordinance that is inconsistent with, there we go, with the Land Use Commission's, with the state law, Chapter 205.
I actually view that question as very nuanced, or the answer to that question is very nuanced. I could not say in all circumstances there can't be an inconsistency, and I'll give you an example of that, just so you understand what I mean by my nuance. There are certain uses, outdoor recreation or open area recreation, that are allowed as a matter of right under Chapter 205. In general, the counties impose some permitting requirements for some uses. For example, zip lining is a use that is considered allowed as a matter of right under 205, but most counties impose some permitting requirements. They don't prohibit it, but they require some approval. In general, whether that's permissible has not been tested by the courts. In general, it doesn't seem to be contravene Obayashi. And so I just offer that as a nuanced approach to it. But as a blanket matter, what you said is true. As a general statement, it's true.
All right. And reading 205-2D, you put that up on the screen, and you said it describes general use. But the chapter does have a mandatory shall. So, and you just agreed with Commissioner Okuda's reading of the declaratory ruling in Godfrey, where it did say that the use has to be related to an agricultural activity. Right? You would agree with that?
Related in a broad sense, it has to meet the statutory definition of farm dwelling.
Okay. And farm dwelling, if we look at both what you agreed to in the Godfrey decision as well as 205A, 2D, has to be related to an agricultural activity.
The specific relationship is either in connection with a farm or the family who occupies the dwelling receives income from agricultural activity. So
Okay.
that would be the specific relationship.
All right, very good, very good. Okay, actually, you have answered my questions. Thank you very much.
Thank you, Commissioner
My pleasure,
Chang.
Commissioner.
Commissioner Ohigashi.
I'm even more simple than Arnold. But I want to ask you this. You mentioned a state, that we would be adopting a statewide rule. Can you expand on that or explain to me further how that happens, or how is that happening in connection to this?
Absolutely, Commissioner. You broke up at the end of that, but I think I understand what you're asking me. And if I get it wrong, I know you will not hesitate to tell me. The granting the county's petition would have, in effect, I should say, impose a statewide rule. And the way it would do that is this. The county has defined short-term idiosyncratically. It hasn't, no other county defined short-term the way the county of Hawaii does. To the county of Hawaii, it is short-term if the lease is less than 31 days. And it does not matter who the tenant is or what the tenant is doing. No other county has done that. It is entirely idiosyncratic to the county of Hawaii. If you grant the county's petition, you are in fact declaring that a farm dwelling may not be rented for less than 31 days. That is the fact of granting the county's petition, because that is how the county has defined short term. So if you grant the county's petition, you are imposing that idiosyncratic rule, black or white, up or down, 31 days or not, statewide, because Chapter 205 has statewide effect.
So we would be conducting rulemaking if we grant that declaration? Is that what your position is?
No, not at all. Not rulemaking, Commissioner. That's a completely different process, both under your rules and under the statute. You'd be interpreting Chapter 205, declaring the application of Chapter 205 to a specific set of facts. Those specific set of facts are that short-term means less than 31 days. And so in declaring that to these specific set of facts, you have interpreted Chapter 205, existing rules, existing law, to mean that no farm dwelling may be rented for less than 31 days.
So by that token, would adoption of your petition or your version of your petition invalidate counties like Kauai's 30-day or 31-day time limits?
No, Commissioner. No, for a couple of reasons, if I may. One is that no other county approaches it the way the county of Hawaii does. And so Kauai does something entirely different. Maui does something entirely different. Oahu does something slightly different. Maui and Kauai are completely different in their regulatory structure. And so in granting our petition, which is simply that Chapter 205, as of a particular date, did not require rentals to be at least 31 days, as a practical matter, has no effect anywhere else. But beyond that, as a legal matter, all it is a negative declaration, right? It is not an approval of any use. It is not a invalidation of any use or of any law. It's simply a negative declaration. State law on this date did not set a minimum rental period. That's as far as it goes. And so both as to practical and as to legal, it has no effect beyond that declaration.
So then my next question would be, are you saying that only that portion that sets the date of 1970, what was it, 1976? I didn't write it down here. But only the time, the retroactive application or the statement that it goes back to, I believe, into the 1974 statute, only that portion is being contested by your petition?
You broke up for me again a little bit, but I think I caught the gist of it. Maybe not every word, but I think I got the gist of it. What I would say in response is to take a minor step back. As I talked about with Commissioner Okuda, we're not contesting or asking the commission to invalidate or declare invalid any portion of any law, the counties or otherwise. That's not at all before the commission. As for the date, we have looked back to, or we have focused on June 4th, 1976, because that's the date that the county selected. So in the county's mind, the county's understanding of Chapter 205 is this. Before June 4th, 1976, state law allowed renting dwellings on ag land for less than 31 days. After, or as of June 4th, 1976, state law did not allow renting dwellings on ag land for less than 31 days. That's the county's understanding. The entire factual situation based on that standing is before you. So the entire factual situation are all of the elements of 2018-114, bedrooms, owner occupant, and duration. We have focused on duration because that's the only matter in dispute. The only point where there has been any argument that the county's petition or the county's approach should be approved or granted, right? And so as to bedrooms, nobody argues that state law regulates bedrooms. As to owner occupant, nobody argues that the owner can't rent the property. The only thing we've argued about is duration. And in the course of these proceedings, as we put up on the screen, both the county and OP have conceded that Chapter 205 does not regulate duration. And so the declaration that we're asking you for, in our mind, after those concessions, is entirely uncontroversial. As in my one sentence to Commissioner Wong, Chapter 205 did not require farm dwellings be rented for 31 days or more, is entirely consistent with what the county has told you and what OP has told you. And so at this point, it shouldn't be a controversial ruling.
Well, thank you for the long explanation, but my question was really, and maybe you didn't get it because it broke up, but I'm just trying to break it up. You
Sure.
have my understanding is that you've conceded that they can make stricter rules within the agricultural district, and we've all understand that. The 30-day, so the 31-day or 30-day rule, the 31-day rule that they have applied, your declaration is, your petition seems to be concerned only with that portion that relates back to 1976. Was it 1976? Is that? Yeah.
Yes, Commissioner.
1976. But you don't disagree that they could put a 31-day definition in that, in controlling what STVRs on in agricultural areas, agricultural districts.
You mean going forward?
Yeah.
We have not contested that because that's not an issue before the commission or something that the commission could rule on.
So your only question is whether that 30 days or 31 days relates back to June 4th, 1976, which I'm not sure whether or not we can issue a declaratory ruling on that particular issue. You know, I'm only I'm just trying to break it down so I understand it. It seems to me that if everybody agrees that the 30 days, because every county has done it, they've set limits, right? 31 days, 180 days. And it doesn't sound like you've yet conceded that the 30 days, 31 days is applicable. Your question that puts it before the Land Use Commission is the June 4th, 1976 provision that you've interpreted to relate to a Land Use Commission, the day that the Land Use Commission would be able, or well, let me put it this way: your relation is the June 4th, 1976 date. That's your concern. Is that right?
Yes, I think the answer is yes. I did have some trouble following again, and I'm sorry for the technological limitations, but I think the answer is yes, and it's simply declaring the law as of that date. It's not declaring what the county can or can't do on that date or after that date. It's just declaring the law as of that date.
Okay. No further questions.
Thank you,
Thank you, Commissioner. Commissioners, are there further questions for Mr. Chipchase at this time? I have a series of questions, but I want to defer to my fellow commissioners. Any hands? There will be, I think, one last bite at the apple after closing arguments. Mr. Chipchase, I have 4 questions for you. How many of your clients are full-time residents of the state of Hawaii?
I do not know the answer to that, Chair.
Do you have an estimate?
I do not. I couldn't even speculate. I don't know. I haven't asked.
How many of your clients receive any of their income from farming on the parcels in question?
I do not know, Chair. I have not asked.
Okay. One of your clients is Psalm 133 LLC. Is that correct?
I believe that is among our client group, yes, Chair.
Okay. Do you know what the first line is of Psalm 133?
I feel like I'm about to find out, Chair.
How very good and pleasant it is when kindred live together in unity. Can I at least infer from the name of that LLC that perhaps those clients live on this property full-time and farm? Or is that a not fair assumption?
It would be, just for me, it would be a disservice one way or the other because I don't know.
Okay. My 4th and final question. If I understood the core of your main petition, it's that the definition of farm dwelling in 205 4.5 does not specifically state the length of time which the farm dwelling may be rented. Is that essentially the core of your, and the county ordinance restricts this?
I would say does not regulate or set a minimum period rather than specifically state, but in substance, that reflects what we have asked the commission to declare.
So, but I guess the problem I have with your argument is like in terms of legislative drafting, Section 4.5 is a list of affirmative allowed uses. I'm not sure why the legislature would include in a list of affirmative allowed uses what is, by the way, not allowed. It just would be implied that when they say farm dwelling, they're not talking about TVRs. Or they would have said, we also will allow units for transient vacation rental. That's the problem I'm having with your argument.
And so let me try to address that problem, Chair, because I think it is an important problem to have and to work through. And so if I may, it reflects a dichotomy between, or an inconsistency, I guess I would say, between how the county has approached regulation and how 205 approaches regulation. Chapter 205, as you pointed out correctly, focuses on use, how the property is being used. The county has focused on duration, how long someone is there, how long a lease is, not on use.
But well, if I may, if I understand their arguments correctly, it is clear that if you were staying for the weekend, you're not farming in any meaningful sense, common sense of the word that regular people would understand. I'm going to Kona for the weekend to farm. Is not something people say. So it is about
yes,
use.
Chair. It's not about use, Chair. It's not. You can have a month-to-month tenancy under the state landlord-tenant code that is exactly what it purports to be, month-to-month. So 30 days on any month that is less than 31 days. That use, that duration, would be considered a short-term rental under the county code. And it would not matter whether that month-to-month lease was issued to a farmer who is farming the property for 15 years, but simply on a month-to-month lease. It would still literally be, under the county code, a short-term rental, and nothing else would matter. So the county, unlike Kauai and unlike Maui, have not approached it from a use perspective. They've approached it, this county has approached it purely from a durational perspective. And so that, with respect, is the way the county has done it. It is not about use. It is only about duration. Now, that does take us outside of the questions that are before the Land Use Commission. The only question before the Land Use Commission on either petition is there an inconsistency between these definitions? And the only component of those definitions that has been argued is this durational component. Does Chapter 205, 4.5, impose a minimum rental period for the rental of any farm dwelling? It still needs to be a farm dwelling because Chapter 205, 4.5, as you said, focuses on use. The question is simply how long does a person have to be a tenant conducting what indisputably has to be a farm dwelling use under the code? And that's the only question because of the way the county has approached this issue. If they had approached it a different way, we wouldn't be before you, or at least we wouldn't be before you on petitions addressing that issue.
Your hypothetical farmer who has a 30-day or month-to-month lease of an agricultural land now being prohibited. I mean, the remedy for that actual farmer would be to simply get a 32-day agreement, right? It's a kind of thing that's available to him to keep farming that no vacationer would ever want to engage in.
Well, I think, Chair, you've hit upon another problem with the way the county approached it. And I mean, we are far afield of the issue that's before you, but I understand that the issue is interesting.
This all goes, I mean, if I'm far afield, I apologize, but I'm trying to go to the core of your written petition that said it's all about What's
Yes,
in 4.5?
correct, Chair. And nothing in Chapter 205, 4.5 as of June 4th, 1976 would require a farmer to have a minimum lease period of 32 days. And indeed, the landlord-tenant code would then be in conflict because it says you can have a lease of any period, and including a month-to-month. It defaults to a month-to-month in a number of circumstances, including after the tenancy is expired or if there is no written rental agreement. So that would, to impose that requirement would create a conflict between these two code provisions, these two chapters. The reason I say it's far afield is because that does get into hypotheticals and into factual situations that are not before the commission. The only thing before the commission on a factual basis is the way the county has chosen to define short term in its code. And the only disputed element of that is duration. And I say disputed with air quotes, and they don't come up as well or show as well on screen as they might in person. I say disputed as to duration because the county has already conceded that Chapter 205 does not set a minimum rental period. And so that's as far as any declaration from this body goes. It doesn't get into the other issues that you raised as possibilities.
I don't have anything further. Commissioners? Anything more for Mr. Chip Chase at this time? Okay, Commissioner Chang.
Yeah.
Thank you, Mr. Chair. And this is just a follow-up in the chair's questioning, Mr. Chip Chase. Since in his lines of questioning about what your clients are doing or not, and we would all, and you had no idea, and you never asked the questions. So we would agree that those facts are really not an issue. But those facts may become an issue when the county decides to enforce. So if there is a determination by the Land Use Commission defining, because you would agree that the Land Use Commission has the authority to define what are permissible uses within agricultural zone lands. Would you agree?
I would not agree that the commission could define those uses in any way that is inconsistent with the statute or the rules.
And I should have been clear about that. So long as our interpretation is consistent with the statute, that is really what is before us, is the commission has the jurisdiction and the authority to define state law, chapter 205, 4A, to define farm dwelling, right? You would agree?
No, I wouldn't agree, Commissioner. I would have to say you have the authority to declare the application of that definition of farm dwelling to a specific set of facts. That's where I think you have jurisdiction, not to declare abstractly, because the legislature has already declared what farm dwelling means. You could apply that definition to a specific set of facts, and here those facts arise from the ordinance.
So who has it? Who has the authority to define, to interpret 205A 4A if it's not the Land Use Commission?
Well, interpret and declare, I would view differently. You have the authority to interpret the law and declare it as to a specific set of facts, not to declare it in the abstract or to declare what it means in any way that differs from what is set out in the code. So I think we're on the same page, more or less. It's just I'm trying to be very careful in how I explain it, because I do think there are a number of nuances that go along with these terms.
And I do appreciate always your caution on how expansive or how narrow. So, but you would agree that it is the Land Use Commission who is responsible for whether it's declaring or interpreting state law, Chapter 205.
As to a specific set of facts.
Okay.
So if we come back to my colloquy with Commissioner Okuda in Chapter 100, you can't declare it speculatively, hypothetically, or to situations that are not before you. You can only declare it as to a specific set of facts. And so that's why both parties have stipulated the only fact before you is 218-114 county ordinance.
And if the Land Use Commission declares that farm dwelling must be related to an agricultural activity, then it would be up to the counties to adopt appropriate rules or ordinances that are consistent with that. And if they determine, or let me withdraw that. So it would be at the point in time when the county enforces their ordinance or their rule that they would look at your client's individual application. So if your clients are not doing any activity that's related to an agricultural activity, you would agree that it would be within the jurisdiction or authority of the county to deny your clients or to find your clients in violation of their rule or ordinance.
So if the county had enforcing on a prospective basis, on a going forward basis, I would agree the county on a going forward basis would be responsible for enforcement on a case-by-case basis, and that you would look at each use and determine whether those uses met the definitions of farm dwelling on a going forward basis. I think I understood that to be the question, and to that extent I agree.
Okay. Okay, you've answered my question. Thank you.
Thank you, Commissioner.
We have Commissioner Okuda going, and Commissioner Cabral would like to also ask some questions. Process-wise, I apologize to my fellow commissioners and the parties. I should have shared my intentions yesterday. My hope is that we could take an early lunch today, take a lunch break after this set of questioning, and then for about 45 minutes and resume during the normal lunchtime hour with this. So maybe go for another 10 minutes or so, break till 11:20, start up again at noon. Is there anybody who has to be here who has a problem with that schedule?
No, Chair.
Okay, great.
And Chair, this is Commissioner Chang. My only restriction is I do need to leave by 3 o'clock today.
Yeah, our intention is, and I suspect that we will not be able to get done before lunch, but we will be able to get done before that deadline. Okay, so with that, let's take up Commissioner Okuda and then Commissioner Cabral, and if there's nothing further from the commissioners, we will then take our lunch break.
Thank you, Mr. Chair. Mr. Chipchase, a follow-up question to your responses from the chair. If you don't know what your clients really do with respect to occupancy, isn't it now, in fact, speculative about whether or not your clients even have standing to bring this petition?
No, Chair, because, or no, Commissioner. I didn't mean to promote you, Commissioner Okuda. No, it's not speculative, because if we set out factually in the petition, and is undisputed, my clients have and desire to rent dwellings within the agricultural district for terms of less than 31 days. And so that is the only element of standing necessary, the only connection, the interest, I guess I should say, the only interest necessary to convey standing, because the only declaration before you is whether Chapter 205 prohibited rentals of less than 31 days as of June 4th, 1976.
Okay, thank you. No further questions.
Thank you, Commissioner Okuda. Commissioner Cabral.
Yes, thank you. My apologies for missing some of the opening statements this morning. But what I wanted to kind of question is, since everything seems to be, Mr. Chipchase seems to say everything matters because it doesn't matter what you're doing on the land as long as once you're allowed to be less than 30 days. So I got a problem with that, because it isn't the premise of zoning is that then the government can somehow decide where activities are. So can, and I have a lot of acreage out there that I rent out, et cetera, that's ag zoned. So if somebody's less than 30 days, based on Mr. Chip Chase's statement just a few minutes ago, I could go ahead and rent it to someone that could put a bar up. They could put a concession stand. They could put a 7-Eleven in there as long as the lease is less than 31 days. I mean, you know, I think I'm getting so spun around with all of this. So Mr. Chip Chase, are you really saying less than 31 days is all that matters, and what they do on the land doesn't matter once it's less than 31 days?
Let me try to unspin you as best I can.
That's hard. I'm simpler than Arnold.
See, I know when any commissioner tells me that I'm in trouble, but I will try to unpack it. So the use is the structure at issue is still a dwelling, and that has a particular meaning under 205 and under county code. And so we're not dealing with, you know, commercial or other kinds of uses. We're dealing with uses that occur in a dwelling. And if we take a step back, what the county has consistently told you in these proceedings is that it regards a purely residential use, no farming at all, regards a purely residential use as still meeting the definition of farm dwelling. So you can have just a residence with no agricultural activity in the county, and they will still call it a farm dwelling. That's been abundantly clear over these 3 hearings now. What the county has done is to say, if you're renting that dwelling, that single family home, to someone for less than 31 days, then it's an illegal short-term rental. If you rent it for 31 days or more, we don't care whether it's for farming, for residential, for vacationing. We simply don't regulate it, right? You can use it for any of those purposes. A 7-Eleven, a commercial and industrial use, you can't put a cement plant, batching plant on there for lots of other reasons in other parts of the code. But for the dwelling use, if it's less than 31 days, it doesn't matter why you're using it. You can be a farmer farming it, and the county would say that's illegal. If you're 31 days or more, it doesn't matter why you're using it. You could be a farmer, you could be a resident, you could be a vacationer. The county would say it's legal. That's the line the county has drawn on purely duration. And what we've asked, to come back to my one-liner to Commissioner Wong, all that we've asked is that the commission declare that as of June 4th, 1976, Chapter 205 did not set a minimum rental period. Chapter 205 did require that the dwelling be a single-family dwelling. Chapter 205 did require that that single-family dwelling be a farm dwelling, and a farm dwelling must be either used in connection with the farm, or the family that occupies it must derive income from agricultural activity. All of those things are part of 205, and none of those things change with a declaration here today. None of those other things are before the commission. The only question is, within that definition of farm dwelling, within those requirements for use, does the law also require a minimum rental period? That's it. That's the only thing before the commission. Did that help at all?
No, in my opinion, you've negated yourself by that concise, because you've said that this whole thing over and over and over again, and I read all your papers last night that have come in the last several days, very elegantly put. But the problem I keep having is that it's the use that matters, and the fact that it's 31 days more or less is not the fact that a vacation rental is then like a hotel. The fact that, so if on ag land we have a 100-room quote residence, because people live there the weekend they come in and rent. So if I'm living, that's wherever I sleep tonight is where I live, you know? So, I mean, I can understand that, but that's my problem, is that I think it's still, the county has enormous problems that need to be cleaned up. I live with this all the time in Hawaii County, and I think they need to, the government officials on state and county level need to figure out a way to clean up this mess with zoning and ag zoning and farm dwellings and the Band-Aid they've put on it to get around things, in my opinion. But I just still do not see that a vacation rental, short-term vacation rental for a short-term period where transient accommodation taxes are due in any way, shape, or form is connected to being a farm dwelling. So I still have a problem with that connecting piece to farm dwelling. But I don't think we're going to figure out a way for me to connect those. So I thank you very much.
Thank you, Commissioner Cabral. Commissioners, I want to assess where we are in our proceedings. And I want to note, just to be extra and completely clear, my intention is that Commissioner Cabral will be able to continue with these proceedings and deliberate on these proceedings. I would like Mr. Chipchase, you or Mr. Gooden, to share your PowerPoint with the LUC staff and the Hawaii County parties so that Ms. Cabral can review it over lunch.
Yes, Chair, we'll do that right now.
Okay. And is there any more questioning of the parties at this time? If there's not, then we'll go on to a lunch break. When we resume from lunch, we will hear closing arguments from the Hawaii County and anything further Mr. Chipchase has to add, and then proceed to questioning of all the parties who all the individuals and organizations who provided testimony who are available, including, if possible, OP. Is that fine, folks?
Chair, I have a quick question.
Yes.
I was wondering whether the commission has received the City and County of Honolulu's submission dated August 11, 2020 regarding.
So there were a number of materials which were not a number of materials, at least two pieces of testimony, including the city and county's testimony has been received by the commission. It was not posted to the website because it was not within 48 hours of the hearing.
Okay, thank you. And also, my understanding was that the Office of Planning was going to chime in. Is that still happening?
So the Office of Planning is not a party to these proceedings, but they are available to be questioned as a public witness. And certainly one of the commissioners can ask the Office of Planning to state their position.
Okay, thank you.
Okay, anything further, folks? If not, let's resume at 12:15.
Okay. And I'll stay on to watch my PowerPoint.
So Nancy, the PowerPoint will be emailed to you, so you don't need to.
Okay, thank you very much.
Okay, thank you. We're in recess.
I think I got it.
Okay, great. Okay, I think we're ready to go, and it's right on time. We're resuming our proceedings, and I believe we're now at the portion of the proceedings where we would hear closing arguments from Hawaii County.
Thank you, Chair. Again, for the record, John Mukai, Deputy Corporation Counsel. The ROSEHILL petitioners in this case argue in their submission that, quote, the use of the dwelling does not matter to the county. We would simply disagree. The county's entire petition seeks to have this commission declare that short-term vacation rentals are not a permissible use for farm dwellings pursuant to Hawaii Revised Statutes, sections 205.2, 205.4.5, and section 15-15-03 of the Hawaii Administrative Rules. This has nothing to do with the county code or the interpretation of the county code. The county wants direction in working toward aligning with HRS section 205 and firmly believes, along with the other county jurisdictions, that a farm dwelling must be used in connection with a farm and have agricultural use attached. The county has determined that short-term vacation rentals are not an allowed use based specifically on the law. HRS Section 205-4.5A provides two permissible uses for human habitation. A4, a farm dwelling used in connection with a farm or where agricultural activity provides income to the family occupying the dwelling. B14, agricultural tourism, which would be activities which provides for overnight accommodations, which requires agricultural activity as well as a separate and distinct process from the short-term vacation rental process. In this case, the Rosehill petitioners are not farming their land. They're not occupying these farm dwellings or deriving their income from agricultural activities. The only way to qualify for a short-term vacation rental is to not live on the property. Now, I know the chair asked Mr. Chipchase for some information, and we took a look at the real property tax records, and the mailing addresses for 19 of the petitioners has one in Honolulu and one in Hawaii. The rest are all out of state or out of the country. The County of Hawaii has never argued about the duration of the farm dwellings being rented for 30 days or less, or whether the owner of a farm dwelling needs to reside in the dwelling. But the use of the farm dwelling is essential in determining whether the Rosehill petitioners may use their farm dwellings as short-term vacation rentals. The county requests that the State Land Use Commission uphold what we believe is the intent of your state land use law by finding in favor of the County of Hawaii and declaring that a short-term vacation rental is not a permissible use of a farm dwelling in the state land use agricultural district. Thank you.
Thank you very much, Mr. Mukai. Commissioners, questions? Commissioner Cabral, followed by Commissioner Wong.
Yeah, thank you very much. I want to follow up exactly on that, on your statements you just made, and so I get absolute clarification. From what I'm hearing you say, and let me know if that's correct or incorrect, is it possible that I could have agriculturally zoned property, have a residential house on it, that I do operate as a short-term vacation rental, because in addition to the visitor staying there, part of their activities of being there would be, or the party, not necessarily a visitor, could be that they would be horse riding activities are part of the stay, or that they would participate in some kind of organic gardening type activities, or produce a crop, or participate in some way, shape, or form in some kind of agricultural, clearly agricultural activity on that land that they are staying on. Would that be one allowance for a short-term vacation rental? And or that they could be short-term on the land if they were to be like, I hire people to come through once a year to pick all my crops, or to do some kind of clearly, I think one of the letters we got or something said like you come in and once a year you pick pineapple and you stay on the land for possibly less than 30 days. Would those be acceptable activities on agriculturally zoned property that one could be possibly defined as short-term vacation rental? That's my question.
I think, Commissioner Cabral, in that case where you would bring someone in, I think you'd be paying them to harvest your crops, right? So I think it's a little different situation.
Okay, that is correct.
But with the other examples you gave, we would submit that we don't believe that would be a short-term vacation rental, but it would be agricultural tourism or getting special permits.
Okay, so my first scenario where they can come in and they stay a week, and part of that week is they get to ride the horses, they plant some type of, I'm thinking organic because it'd be small time, but some kind of crop or something. If that is the experience that's offered and marketed with that vacation experience, is that would that be considered a permitted use because it involves agriculture activities?
Again, we would submit that would be covered by ag tourism because they would be paying to come in and do that activity pursuant to the ag tourism statute.
Okay, I see what you're saying. Thank you very much.
Thank you, Commissioner Cabral. Commissioner Wong, followed by Commissioner Chang.
Thank you, Chair. I just have one question again for the county. It's in one sentence, what are you asking us to do?
The county wants the Land Use Commission to find in favor of the County of Hawaii by declaring that a short-term vacation rental is not a permissible use of a farm dwelling in the state land use agricultural district.
Okay. Thank you for that statement. Then I have another question for you. Mr. Chipchase was talking about a date, 1976. So how does that relate to your DR?
Well, Commissioner, I think that's when the definition of farm dwellings was established. So that's why at that point in time, the county believed that short-term vacation rentals could not be used on farm dwelling units in agricultural districts.
Okay. So it seems like there's some connections with the two DRs, but somehow different in a sense that one's dealing with date and one is dealing with yes or no. Or am I mistaken?
I think the county's position deals specifically with the use of the short-term vacation rentals is not permitted in the agricultural district on a farm dwelling.
Okay, that's it. Thank you, County. Thank you, Chair.
Thank you, Commissioner Wong. Commissioner Chang, followed by Commissioners Ohigashi and Axon.
Thank you very much, Mr. Mukai, for your testimony explaining the county's position. And I know this has been a kind of an evolving process. So I just really want to be very clear that the county's position, and when you refer to short-term vacation rental in your responses, you're using that as a term of art as you have defined under your own rules. Is that correct?
That's correct.
So in that instance, it's like the owner operator doesn't reside on the building, there's no more than 5 bedrooms, and is rented for a period of 30 consecutive days or less. So when you say short-term vacation rental, that's what you mean?
Yes, Chair.
Okay.
I mean, yes, Commissioner.
Okay. So, and now what I'm hearing you say is that the use of the land is essential to determining whether the landowner is in compliance with 205.4.5. That's the county's position, is that use is important, is critical.
Yes, that's the county's position. Commissioner.
Okay, so when other commissioners in the previous asked about, I think it was Commissioner Wong about the McMansion, about Commissioner Okuda is questioning about, I have no intention to farm or conduct any agricultural activities. It is now the county's position that you are clarifying that, and I don't want to put words into your mouth, but are you now saying that the use and the intention of the owner is important for purposes of fitting within the definition of 205-4.5A4?
And Commissioner, I'll have Michael Yee, Planning Director, address this point.
Hello, Mr. Yee, you're still under oath.
Yes, Michael Yee, Planning Director for Hawaii County. In the line of questioning previously, the question was whether or not we would issue approval for a farm dwelling unit if we clearly didn't know they were going to, let's say, farm. But the line of questioning did not continue to when would we issue a violation if a use was on that same property. It also, that use of occupying just as a single family dwelling or as a single family in a farm dwelling unit, if you're occupying that, it doesn't negate from having to do farming activity. So that's the question, which is, we see as a vacation rental full-time, 24/7, as being inconsistent. So to say somehow like it's not important to us, that's also the line of questioning go in as far as why would we then, when we issue a second farm dwelling unit, why we ask for sales records for farming activity. The line of questioning didn't go toward when do we issue violations for uses that aren't permitted within farm dwelling units. So we, to somehow say it doesn't matter to us is inaccurate also, because it really does matter to us that you can certainly live on your property, but we also like to see agricultural activity.
Okay, so and today you have an opportunity to clarify, and perhaps the commissioners didn't give you an opportunity to fully expand on your question. So now it's my understanding that the County of Hawaii is saying that that a farm dwelling, to be a farm dwelling or to have a residence on agriculturally zoned lands, it has to be a farm dwelling where it is located or used in connection with a farm, or where the agricultural activity provides income to the family occupying the dwelling. Is that correct?
That is correct.
And it also, is it also correct that the county's position is that the activity has to be related to agricultural purposes?
Yes. Yes, that is correct.
Okay. That's very helpful. And then you have this exception for agricultural tourism, which goes more towards duration, short-term uses. But again, it has to be consistent with its agriculturally related activity. Is that correct? Correct.
So I do want to just also say, so when you throw out a bunch of scenarios, it's difficult because as planning directors, we go case by case. And so when you come in and state some kind of use, it could be a vacation rental. It could be a special permit. It could be ag tourism, right? And to just throw out scenarios sometimes is difficult because there has to be a complete application, a package to us that's telling us what's going on. And so just want to provide that input.
And I appreciate that. I mean, I think, and I will only speak on my behalf, I think at times the county, when you refer to short-term vacation, is very clear in your mind, you are looking at the definition of your short-term vacation rental under your rules, and it meets those requirements. And sometimes in my mind, when I was asking questions, I was thinking more of sort of a generic situation where someone is not conducting agricultural activities, but they're using it for something less than the duration. So you clarified for me what your county position is. It has to be related to agricultural uses, and it could be less than 30 days, and that would fit under your agricultural tourism. Is that correct? That's okay. That's what I heard you say.
That is correct.
Can I ask, why did the county, and you may have already answered this, Mr. Mukai, select June 4th, 1976?
Because that's the date when the definition of farm dwelling was established.
Okay, but you weren't saying that anything that happened after June 4th, 1976, short-term vacation rentals would be permissible. You aren't saying that, are you?
No, we're saying the county's position is that they're not permissible uses after 1976.
Okay, so you're essentially saying they have never been a permissible use under your own county ordinance.
That's correct.
And the state.
And the state statute.
Because to be honest, I don't even know if the term short-term vacation rental even existed in 1976. So what I'm hearing the county say is that in your position is that short-term vacation rentals, as you have defined it, was never a permissible use on agriculturally zoned lands.
That's correct.
Okay. So there would never be a grandfather situation. It just was never permissible.
Correct.
Okay. Do you know, this is kind of a factual question, do you know whether any of the petitioners under the ROSEHILL petition ever applied to the county for a non-conforming use certificate for short-term vacation rental?
Commissioner, are you asking whether they applied for a short-term vacation rental, or
Yes, because in your petition you said you received some applications for short-term vacation rentals on ag land. So I was just wondering whether any of the petitioners applied.
All of them have applied, Commissioner.
So there is an admission by the petitioners that their activity falls within the definition of your short-term vacation rental.
That's correct, Commissioner.
So they may not have shared those factual information with their counsel, but their application that they submitted to you all falls within the definition of short-term vacation rental.
No. I think that's why.
This is April Supernaut, Deputy Planning Director. So all of the petitioners have applied for a short-term vacation rental with the county and have been denied because they did not fit the parameters of the code in our county code.
And
so part of the reason why we're here today in front of all of you is because they were denied, and why Mr. Chip Chase and the ROSEHILL petitioners have filed a counter petition to the LUC is because they applied for their short-term vacation rental and were denied under the county rules and code.
And they were denied because they're on ag zone property, ag zone lands, right?
That is correct. That is correct. They are all on ag property and parcels that were created after June 4th, 1976. Therefore, we consider all of their dwelling units on their property to be farm dwellings. And by definition of a farm dwelling does not explicitly allow for short-term vacation rentals or the like. And 205 4.5b also says use is not expressly permitted in subsection A shall be prohibited.
Okay, so I'm asking because I've not seen the applications that they submitted to the county. So, and you may have. So did all of their applications say that they are the owner or operator and they don't reside on the house?
Commissioner Chen.
Yeah.
I'm just throwing up a yellow caution flag in terms of how many facts we're trying to get to versus the acceptance of the facts here.
Okay, I'm not sure
Please,
what you.
please continue.
Okay, I just want to make sure because this is different, contrary to what we heard from petitioner's counsel. So, so they don't reside on the property, and that they don't have more than 5 bedrooms on the property, on the house. Do you have a checklist that says that?
We would have to go back and re-look specifically at the bedrooms. And I appreciate the line of questioning. In order to try to qualify, which the petitioners did try to qualify for an STVR, being that they applied for a short-term vacation rental, part of that statute says that they do not and cannot reside on the property. So we would presume that whether they live there today or not, that they were planning to not live there if they were to be issued a short-term vacation rental permit.
Okay.
But they were not issued those permits.
Okay, so I'm assuming that there's a self-declaration. They know what's required under a short-term vacation rental, and therefore they submit the application. Okay.
There is an affidavit that's part of the application that specifically outlines that they will be in accordance with the laws and rules and regulations, et cetera, et cetera.
Okay. All right. All right. You have answered my questions. Thank you very much.
Thank you very much, Commissioner Chang. We have Commissioners Ohigashi, then Axon, then Giovanni, then Okuda.
Yeah, I'm assuming that the ordinance was passed properly and signed by the mayor.
Yes, that's correct.
So, and it contained essentially 3 subjects, right? Three requirements, 3 standards.
Yeah.
One.
Yes.
Why don't you go over that for me again? Those 3. I just want to be sure I'm looking at it for.
The provisions in the code require a lot of things. So exactly what is it you want us to take a look at?
The owner-operator doesn't reside on the building. There's no more than 5 rooms to rent. So your STVR if the owner doesn't reside on the building, right?
Yes, sir, that's correct. This is April Supernaut again. So the definition, the county's definition of a short-term vacation rental means a dwelling unit of which the owner or operator does not reside on the building site, that has no more than 5 bedrooms for rent on the building site, and is rented for a period of 30 consecutive days or less. And further, it says this definition does not include short-term vacation rentals of an owner's primary residence as defined under a different section of the IRS code or the Internal Revenue Code. So those are the three items that I think you were referring to that Mr. Chip Chase has had slides on.
And your question is, it's not the 30 days question or anything like that. Your question is merely, is your ordinance consistent with 205 4.5A4, which does not include vacation rentals or the use of property for vacationing purposes that is not related to agricultural use?
Commissioner, this is John Mukai. We're not asking you to interpret our ordinance, but whether or not this vacation rental is a permissible use of a farm dwelling in the state land use agricultural district.
So if we say that a vacation rental is not a proper use in an agricultural district, would that mean that your ordinance wouldn't even apply?
It would apply. It's just that it wouldn't apply to farm dwelling units in agriculturally zoned districts.
Which is what our code says.
So the question then turns then is that the argument is whether or not it's a farm dwelling.
No, I don't think so.
Well, if it's not a farm dwelling, then it wouldn't apply. You're saying.
Well, all of the lots, they're considered farm dwellings on the agriculturally zoned property. So it needs to be, we believe, connected with agriculture activities. So I don't know how else.
What I'm trying to get at is one. I think the question is whether or not a farm dwelling can be used as a rental for the purposes of vacationing people, short-term, for non-agricultural, essentially for non-agricultural purposes. That's the central argument that you're trying to make. The second part about it is that how the county is going to enforce that rule. And they're going to enforce it by saying, well,
I think I'm sorry. Okay.
So that's my question. My question is, if we grant what you say, then whether or not you define it as STVRs or whatever, it is clear from it. If we decide that you cannot do these vacation rentals because they have no agricultural purpose, you cannot use these dwellings for that. If we say that and grant you what you want, then technically there's no need to render an opinion or make a ruling on whether or not 1, 2, and 3 of your ordinance applies. Is that right?
Yeah. Again, we're not asking to interpret the code, and with regard to enforcement, that's the planning department's problem, and they are going to be dealing with it, and they are dealing with.
So I'm trying to get a grasp on this. Is that what is in our Kuleana and what is in you guys' Kuleana? If we're not going to wrestle with the ordinance or terms of the ordinances, and we just find that, yeah, you cannot have vacation rentals, and it's inconsistent with the definition in 205 4.5A4, then it's up to you guys to fight whether or not these in another form, whether or not these as county ordinances can be enforced or not enforced, or should be interpreted or go beyond the bounds of constitutional bounds, etc. Isn't that right?
Yeah, that's correct.
No further questions.
Thank you very much, Commissioner Ohigashi. Commissioner Axon, followed by Giovanni, then Okuda.
Good afternoon, Mr. Kai. We probably touched on this one already, based on several ways of questioning by commissioners. I apologize if I'm kind of duplicating it, but I just want to kind of put it on my own way. In the beginning of Mr. Chip Jay's presentation, he mentioned about these three elements. Unfortunately, I don't have the PowerPoint, but I kind of remember about these three elements that he mentioned. Do you agree with that or not? And if not, why?
I think, Commissioner, you're talking about the definition as set forth in the Hawaii County Code. And yes, we do agree with the definition as set forth in the Hawaii County Code with regard to the definition of a short-term vacation rental.
That's the three elements that was on the presentation.
And I think those are the three elements that we chatted with Commissioner Ohigashi about, I believe.
Okay. So you agree on those elements that was mentioned?
They are part of our definition.
Yes, because they are part of the Hawaii County Code definitions of a short-term vacation rental.
Okay. That's what I thought. Okay, thanks. Bye.
Thank you, Commissioner Axon.
Thank you, Mr. Chair.
Thank you. I note that the county chats with people, whereas the Rosehill petitioners have colloquies. Commissioner Giovanni.
Thank you, Chair. So I have been following this rather wonkish legal discussion as an engineer, but I'll try my best to ask the questions that I understand to the county. First, I just want to clarify in the lexicon that short-term is equivalent to transient as expressed in the ordinances of other counties. Would you agree with that?
Commissioner, you broke up. Could you please repeat the question?
The question is, just a clarification, in your lexicon, you refer to short-term vacation rentals. In the lexicon of the other counties, planning departments, they refer to transient vacation rentals. We're talking about the same. Is that correct?
Yes. Generally, yes, Commissioner.
Okay. So I do very much appreciate the testimony that's been presented in writing by the other counties, the planning departments of other counties. And I'm just going to refer to some excerpts directly from the one from the Department of Planning of County of Kauai. And this is their interpretation of HRS 205 4.5A4 is that the farm dwelling would have to be used in connection with a farm or where agricultural activity provides income to the family occupying the dwelling. I just want to ask, is that consistent with your interpretation in Hawaii County?
For a farm dwelling, yes.
Yes, for a farm dwelling. So
yes.
The root of my questioning is the following. In Kauai County and in other counties, there is a process by which you can get an exception under 205-6 for a non-conforming use for a farm dwelling as a TVR, in which you can apply for a special permit. for that express purpose. Is there something equivalent to that in Hawaii County?
Yes, and in fact, these petitioners could do the same thing.
So in other words, what you're saying is that they don't automatically get a permissible use as a farm dwelling under 205 4.5A4. Yet if they want to pursue that as a permissible use, they can get an exception to that under 205-6 by going through that process. Is that, and that is established today. Is that correct?
Well, in that case, it would be a non-conforming use and would require a special permit.
Yes, that's what I'm asking, and you've confirmed it. So thank you very much. No further questions.
Thank you very much, Commissioner Giovanni. Commissioner Okuda.
Thank you, Mr. Chair. And I promise my fellow commissioner, I'll try not to be a wonk. But if I can ask you this, Mr. Mukai, since the little exchange we had on the transcript was featured semi-prominently by Mr. Chipchase in his submittals. So let me re-ask the question again. If I came to the County of Hawaii for a permit for the first structure on a piece of property which is within the agricultural district, and I told you to your face or to the face of whatever person, county employee that was taking in my permit application, and I said unequivocally, no ifs, ands, or buts, I am not going to do any agriculture. I'm not going to farm. And I have many reasons why I'm not going to farm, but I promise you, under penalty of perjury or under penalty of law, there will be no farming activity. There will be no agriculture. I'm just going to live in the dwelling forever and ever and ever. Will you still give me a permit to build my dwelling on that piece of property which is within the agricultural district on the Land Use Commission maps?
Well, we don't issue building permits, but with regard to the farm dwelling, it is a farm dwelling on agriculturally zoned, on an agriculturally zoned district. And of course, the planning department in the County of Hawaii, and as well as all the other respective counties would want and would I guess it would necessitate that agricultural activities be performed.
Yeah, but I'm sorry. Go ahead. I'm sorry. I didn't mean to cut you off.
That it be agricultural activities be performed on the farm dwelling.
Okay, but whichever department or division of the County of Hawaii, I'm telling the appropriate division or department or appropriate employee that would have to issue me the discretionary permit for me to build the dwelling on the property. I'm telling, you know, the county employee, I am not going to have any agriculture. I'm not going to farm. It can be your wish that, you know, I hope in the future, Mr. Okuda, you'll reconsider. But I'm telling you, I'm not going to farm. And in fact, I'm thinking of going to see my lawyer to put a deed restriction in there that says there will be no farming because I hate farming. Will you still issue the permit which allows me to build that dwelling?
Aloha, this is April Supernaut, Deputy Director. So there's a lot of different ways to come at that specific question. There are not specific things that require active farm activity prior to a landowner building a farm dwelling. You could not, under state law, you could not under state law file a deed restriction stating that no ag activity could happen within the state land use ag because that would be counter to the 205 statutes. So we would not, if we were signing off on, we would not sign off on that. But we don't have anything in place that requires active current agricultural activity before building a farm dwelling. That does not mean that the first dwelling on a parcel in the state land use ag district is not a farm dwelling. It is. By definition of 205, the only provision for a dwelling within the farm agricultural district as a permitted use is a farm dwelling.
Okay, but
I hope that answers your question.
well, no, well,
And we would have you sign a farm dwelling agreement. So you'd have to
Okay.
agree to that this is the land that you're building a house on, and that this is what it requires.
okay. So in other words, you're telling me, even though I tell you these things orally, I will have to make a written representation that the dwelling to be constructed will comply with the requirements of 205 or other applicable portions of the law which require agricultural use. Is that what you're saying?
Yes, sir, that is correct. But we could not force you to buy a tractor or put a hoe in your hand to actively work the land. We could not force you to do that, given the statutes that are currently in place. But the dwelling that you build on state land use ag is, by definition, a farm dwelling.
Oh, okay. You know, I might slightly disagree with that because I think even your county's presentation has been use is crucial. Use is the controlling factor. You might not be able to force me to buy a tractor or actually farm, but if I make a statement to a government official in certain circumstances, it is true, I could be prosecuted at minimum for a, I think it's called unsworn falsification to a government official. Okay, in any event, you've answered my question. Thank you very much. Thank you, Chair.
Thank you very much, Commissioner Okuda, and all of the commissioners for excellent questions. Are there further questions right now for the county? Commissioners. Oh, Commissioner Ohigashi.
I just wanted to follow up on that. If they sign the agreement and they fail to, a farm operation fails to materialize, I've seen it on Maui that they aren't given the agricultural tax breaks or agricultural water rates that the county provides for agricultural use. Is that similar to what happens in the Big Island?
Yes, sir, that is correct.
No, I don't have any further questions.
Okay.
Thank you.
Anything further, commissioners? Okay. Even though we've heard a lot from you today, Mr. Chip Chase, you have the opportunity to offer your closing. I'm assuming it will not be as long as your main argument.
This is what happens when I don't have Mr. Gooden with me.
See,
you
this
assume
is why you
correctly,
need to be nice to him.
Yeah, and I always have been. I hear it's not only a binding order, but a continuing one. And so, Chair, I appreciate the opportunity to chat further with you and the other commissioners on this issue. And I know we come to the end of, or nearing the end of a long hearing, you know, that has certainly spanned three hearing days over a couple of months and a lot of filing. And so the first thing I want to say really is just that I recognize how much time all of this takes. and I recognize the effort that the commissioners put into understanding the issues and to making a reasoned decision. And it's reflective of the questions that you've asked me and that you've asked the county. And I also recognize that this is a difficult and a sensitive issue for the commission and in general, because of the nature of a short-term vacation use and the concerns that are associated with those use, particularly on ag land. And so I recognize that it's all something that each commissioner struggles with as they approach the respective petitions. I had some remarks prepared to close because I really think you can break this down into 4 slides, and I will try to do that in a moment. I am compelled to say that I am very surprised by a lot of what the county said in response to questions from the commission. And my surprise is in part because the statements are contrary to things that have been said throughout these proceedings. And it's not, as I look at these quotations that we've set out in our papers and on the slides, it's not a further clarification. It's an utter departure from a lot of what had been said, because among other things, it's been quite clearly expressed to the commission that if we remember how this discussion began with Dr. Bell, Dr. Bell does not farm. He may never farm on his property. He has never expressed any intention to farm. If you recall, he said all those things on our first day of testimony. And the question of the county was, is his dwelling still a farm dwelling? And the answer was unequivocally yes. Not, well, no, but we'd have to enforce it. Not, well, no, but we didn't know that when he erected the dwelling. It was unequivocally yes. It is still a farm dwelling, even though he had never farmed and had no intention of ever farming. That is the truth of the county's position, that a purely residential use is still considered a farm dwelling on ag land within the county of Hawaii. And it's replete in the transcripts. And if there's any doubt in any commissioner's mind, I encourage you not even to take my excerpts at face value. Go back and read the transcripts. That is the county's position through and through. The second thing that very much surprised me was the assertion that the county's code did not matter, that the question is, what is a short-term vacation rental allowed? But very quickly in the questioning from Commissioner Chang, it was apparent that when the county says short-term vacation rental, it means short-term vacation rental as it has defined in its code. Right? Every time you hear the commission or the county say short-term vacation rental, it means its definition of short-term vacation rental. The county was quite clear about that on further questioning. And as we heard in the questioning with Commissioner Ohigashi later, that definition includes 3 specific elements: owner-occupant, 5 bedrooms or less, 31 days or less. That is everything that this comes down to. That is all a short-term rental means. It does not mean anything other than those 3 elements. And so when you hear the county's request is to declare that short-term vacation rentals have not been allowed on ag land since June 4th, 1976, they mean a property on which the owner does not live, that has 5 or fewer bedrooms, and that is rented for less than 31 days. That's all it means. And as we've seen throughout these proceedings in response to questioning, if the lease is 31 days or more, it is permitted. It is not considered a short-term vacation rental. It is not prohibited under the county's code. If it is less than 31 days, it does not matter why the tenant is using the property. It is still prohibited as a short-term vacation rental under the county's code. Transcript is replete with those statements, and we put some of them up on the screen earlier today. The third thing that surprised me is that the county said that a rental of less than 30 days for ag purposes or with an ag connection would be considered ag tourism. But the county code does not allow any overnight accommodations as ag tourism. So in fact, that could not be the use. It would be considered a short-term vacation rental, whatever the purpose, whatever the use is, as long as it is less than 31 days. And the fourth and final thing that very much surprised me is the intimation that, in response to questions from Commissioner Chang, that this short-term vacation rental use, as the county has defined it, the county views that as having always been unlawful on state ag land. That's not true. The county code specifically allows lots created before June 4th, 1976 to obtain a non-conforming use certificate to continue a short-term vacation rental use, so a rental of less than 31 days. The only reason that these lots, the petitioner's lots, did not qualify is because they were created after June 4th, 1976. Had nothing to do with anything else. That is the county's black and white up or down date. Was your lot created before June 4th, 1976? If yes, you can obtain a non-conforming use certificate and continue a short-term vacation use on ag land, meaning a rental of less than 31 days. If your lot was created after that date, you cannot obtain the permit, the non-conforming use certificate. And so I have to bring us back to where we started, and I have to say that I don't believe anything that the county said was about my clients or about our uses was inconsistent with anything that we've said from the beginning. In response to Commissioner Chang's questions, or Commissioner Okuda's questions rather, said quite directly, well, my clients have engaged in and intend to engage in rentals of less than 31 days. In order to do that, they had to apply for these non-conforming use certificates because the county code, black and white, says if your rental is less than 31 days, you are a short-term vacation rental. That's it. And if you want to engage in that use on ag land, you had to apply for these non-conforming use certificates. They don't ask you, what are you doing with your property? How is it used? Do you have a farm? None of that. Are you renting it for less than 31 days? If so, you are a short-term rental and you have to apply for the non-conforming use certificate. If I am able to do this real quick with those points made, I would like to come back to what is actually before the commission, because much of this is not. Oh, I'm sorry, I do have one brief other thing to say. Commissioner Giovanni, I thought your question is short-term equivalent to transient in other counties. It's an excellent question. The answer is no. It's not generally or sort of, it's absolutely not. The other counties define those terms very differently. And Maui County in particular, Kauai County is less familiar with, but Maui County in particular actually has a definition of transient that says you live somewhere else. This is not your principal place of residence. There's nothing like that in the Hawaii Code. The dates are different, the terms are different, the conditions are different. They're not similar at all to the other counties. Kauai has taken a much more thoughtful approach, and I think Maui has as well. So with respect to Mr. Mukai, they're not the same. They're not equivalent in any way. Okay, coming back to what is actually before the commission, now that Mr. Gooden has rejoined me, I'll ask him to put up on the screen just the 4 slides that I would like to share with you in my closing comments.
Oh,
yes, Chair.
I have to, somebody had inadvertently started screen sharing earlier, so I disabled that option for all panelists. Now I need to re-enable it. I will also note, there's a member of the audience who has their hands up, but I would note that we're not taking any public testimony at this time, or at this hearing. Public testimony was taken earlier on. Okay,
very good.
Mr. Gooden may continue.
Thank you. Okay, so this gets back to why we're here, and this is the date that Commissioner Chang talked about, Commissioner Ohigashi talked about, and it was briefly touched upon both in my closing and Mr. Mukai's closing. This is why we've focused on the date. This is what the county has said. The county understood that a short-term use on lots created after June 4th, 1976 was not lawful in a farm dwelling. the county understands that before June 4th, 1976, a short-term use is lawful on the ag district. The phrase short-term vacation rental, as used in the county's petition, the question that is put before you is its own definition. No other definition, no abstract meaning, no label that lacks concrete specificity. In that definition, and we put it back up on the screen, I know Commissioner Axon had asked, did I get the elements right? Yes, you did, Commissioner. These are the elements of it. There is nothing in any of those elements that deals with use. The county said use matters, use matters. It does not under this definition. It is 30 days, no good, more than 30 days, fine. And it does not matter for purposes of this definition how the property is used. It's all about the date. So the only question before you is, does that duration matter under state law? That's it. That's the only question before you. Does the duration matter? And everyone has already agreed that the answer is no. The definition of farm dwelling in the state code does not now and never has cared about the date, cared about how long that property is rented. It only cares about how it's used. Nothing else matters, and nothing else is before the commission. So that leads to a very, very narrow declaration. As of June 4th, 1976, the plain language of Chapter 205 did not dictate how long a farm dwelling must be rented in order to qualify as a farm dwelling. That's it. That, in essence, is the only question that either side has put before you. The county phrases it in terms of, was a short-term vacation rental allowed? But remember, and expressly in response to Commissioner Chang's questioning, when the county says that term, it means that term as it defined it. That term as it defined it is only concerned about duration. And so that is the only question before you. Your consideration of issues doesn't go beyond that. Your jurisdiction doesn't go beyond the petitions. And the petitions do not go beyond this very narrow question. Thank you, Chair, and thank you all commissioners.
Thank you very much, Mr. Chip Chase. Okay, we are just at a full hour after lunch. We have time. I would prefer to take a, oh, Commissioner Ohigashi, excuse me. Go ahead.
I was just going to ask for a break.
Okay. Well, a good chair anticipates the needs of his commissioners, I guess. It's 1:16. I would like to break till 1:26. We will conclude with questions from the commissioners for any of the parties or the public witnesses who are still available, and then we will move to deliberation. We have Commissioners Okuda, Chang, Axon, Giovanni, Ohigashi, Wong. We need Commissioner Cabral. Hi, Commissioner Cabral. Okay, I think we're ready to go. We're back on the record. And commissioners, this opportunity to ask questions of the parties or of any of the witnesses, including the Office of Planning. Commissioner Chang, followed by Commissioner Okuda, followed by Commissioner Wong.
Thank you very much, Mr. Chair. And thank you again, Mr. Chip Chase. Yes, the closing arguments have been very instructive, clarifying various positions. So let me just ask you to make sure that I have a very clear understanding and that you would agree with me as to what the narrow issue before LUC is. Would you agree that LUC has jurisdiction to issue the declaratory order only on HRS 205-4.5A4, essentially definition of a farm dwelling?
Yes.
Okay. And would you agree that the definition of farm dwelling doesn't have anything to do with duration?
Yes.
And would you agree that the LUC is not being asked, nor does it have the authority in this hearing to determine the validity of the county ordinance?
Yes.
And would you agree that 205-4.5A4 does require a farm dwelling be one located on and used in connection with a farm, or two, where an ag activity provides income to the family occupying the dwelling?
Yes.
And would you agree that in addition to that definition, that the use must be related to an agricultural activity?
I would not agree that that's an additional element. I would agree that to the extent that's an element, it's encompassed in the definition.
Okay, that serves my purpose as well. Okay, and you've argued in your papers that that there's potentially a taking, could be a taking if your clients if I guess the date was 1976. So, and you are essentially, as I understand it, arguing that there's a grandfather clause, that your clients were grandfathered and that they're permitted to do short-term vacation rentals as defined by the county. And if they're not permitted to do that, that may be a taking in violation of the Constitution. Is that your argument?
No, Commissioner.
Okay.
Something was certainly lost between my mind and my paper when I typed that out, because that's not our argument. And let me try to unpack it, and I'll be, Jonathan's going to say, or Chair's going to say, not brief enough, but I'll try to be brief.
I will.
Yeah, thank you. We described the impact of the county's retroactive regulation reaching back to 1976 for its effective date, rather than doing what every other county did, which is regulate prospectively from this day that we adopt the ordinance forward. Hawaii County went backwards. And we described the effect of that for the commission merely to provide context as to why that date was so important, why the county selected that date. But it is the constitutional issues surrounding that retrospective look don't have anything to do with the question that the commission is being asked to decide. They're apart for it. And so that discussion is just contextual as to why that date matters and what the county did, being so very different from the way the other counties had approached regulation of ag land. For purposes of just making sure that everybody understands how we see that effect, it's not a takings issue. And I think Commissioner Okuda and I had a great discussion, a great chat about this on June 25th. It's not a takings issue, it's a due process issue, because laws have prospective application. They don't have retrospective application. And in fact, the counties here does. But for purposes of this body and the questions before this body on the petitions, all of that is merely contextual rather than things that we ask the body to rule on.
Okay. That's helpful to understand. So is it fair to say that if that for purposes of 205A 4.1, 4.5A4, that it always required that the farm dwelling be related to agricultural purposes.
I would say it would be fair to say that since June 4th, 1976, farm dwelling has been defined as either being used in connection with the farm or occupied by a family that derives income from agricultural activity. It's only been since that date, and you know, as we talked about, I think on our earlier discussion, I'm uncomfortable defining it in ways that go beyond the text of the definition, but I think that the definition encompasses that concept.
Okay. Again, that's consistent with my understanding as well. My final question to you is, how have your clients been prejudiced, if any, have your clients been prejudiced to date by, let me think about that question. Well, would you agree that, no, you know what, I'm going to just withdraw that. You have answered the questions and clarified for me the scope, at least in my mind, of this declaratory petition and what is before us at this time. So thank you very much.
You're welcome, Commissioner.
Thank you, Commissioner Chang. Commissioner Wong, followed by Commissioner Okuda.
Thank you, Chair. My question is going to go to OP on some of their file of documents that they filed with us.
Yes. So, their testimony.
Yeah, their testimony. Thank you. This is regarding the supplemental response to counties and petitioners' deck orders.
Yes.
So you stated in that testimony that the petitioner's question is speculative and does not provide specific factual situations upon which the commission can make a declaratory ruling and therefore must be denied under HAR 1598A. And also, so can you explain that to me, please?
Well, I think that, sure, Commissioner, thank you. I think that petitioners have very narrowly defined the question, so much so that they have left out certain facts that are pertinent to the commission answering or determining the answer to this declaratory petition. For example,
go ahead.
For example, whether the farm dwelling is used in connection with the farm, or is it used simply for a short-term vacation rental or residence as a transient accommodation? So I think those facts would help the commission determine whether a short-term vacation rental or at least a shorter term of rental could be applied to a farm dwelling.
So when you stated petitioner, is that the county or is that Mr. Chip Chase's clients?
That would be specific to petitioner ROSEHILL et al.
So the question is, because there's, you know, I know there's 2 DRs in front of us. So in the county's DR, so you're saying that they're relevant and it has some facts and it's not hypothetical and all that. Is that correct?
That's correct.
Okay, and that you're saying that the county statements and their DR that no short-term vacation rentals are allowed on ag land. Is that correct?
As farm dwellings on
Yeah,
ag
farm.
land.
Yeah.
Correct. Correct.
Okay. And that so you're stating also that the Rosehill et al., that DR should be denied or thrown out, or is that what you're trying to say?
I think that the county's question is a proper question, and it's a question because the commission can answer it. It can look at what is a farm dwelling under HRS 205 and determine whether it is consistent or whether an STVR as defined by the county is consistent with the farm dwelling definition. So I think that that is a proper question, whereas Petitioner Rosehill's question, they are very, very narrowly asking you to say, look at the definition of farm dwelling and tell me if there is a prohibition on a rental term, which there is not. If you read it, there is simply no prohibition, but that is not the full story. And the full story is about the uses that are involved, the STVR use and the farm dwelling use, which are not compatible. It's either one or the other. So a farm dwelling can only be used in connection with a farm, but if you have a short-term vacation rental use, which is does not have any connection to use with the farm or agricultural use, then it cannot be used as a farm dwelling or in a farm dwelling.
Okay, that's it. Thank you, OP. Thank you, Chair.
Thank you very much, Commissioner Wong. Commissioner Okuda.
Thank you, Mr. Chair. Actually, Commissioner Wong asked most of the questions that I had intended to ask towards the Office of Planning. But if I can just ask then a summary question. So, Ms. Opuna, does after listening to all this additional argument that was presented since the filing of the Office of Planning's last submittals, does the Office of Planning have a recommendation to the Land Use Commission on what a recommended decision would be?
I think our OP's recommended decision would be to deny Petitioner Rosehill's petition and to accept the county's petition as stating that a farm dwelling may not be used as a short-term vacation rental. I could also expand a little bit more about some of the issues that have come up since we did submit our position.
Yes, and that was actually going to be my next question. If there was something additional which has come up during the interim, which is not reflected in your pleading. So can you please proceed further with what you were about to state?
Thank you, Commissioner Okuda. Let me see here. So the issue before this commission is simple, but it has been twisted and complicated by extraneous information and misleading argument. The basic question is whether a farm dwelling may be used as a short-term vacation rental or STVR. The answer is it may not, and there are at least 4 reasons proving this. First, a farm dwelling use and a STVR use are not compatible uses. A farm dwelling is defined under HRS 205 4.5 A4 as a single-family dwelling that either must be located on and used in connection with a farm or where agricultural activity provides income to the family occupying the dwelling. A STVR use is basically a transient accommodation effectively for vacation or tourist use, which has no connection to a farm and is not accessory to an agricultural use and does not meet either of the requirements of the farm dwelling definition. A STVR use would therefore improperly displace the required agricultural use of a farm dwelling. Secondly, a STVR is not a permitted use of a farm dwelling in the agricultural district under HRS Chapter 205. HRS 205 2D and 205 4.5A expressly list the permitted uses of the agricultural district as a matter of law. Importantly, if a use is not listed, it is prohibited. Steivers are not listed permitted uses of a farm dwelling under HRS 205 and therefore are prohibited. Thirdly, residential use of a farm dwelling without any connection to an agricultural use has never been allowed in the agricultural district. The law has always required that a farm dwelling be used in connection with a farm or accessory to an agricultural use, and not just for residential uses, and certainly not for steiver uses. The date June 4th, 1976 is therefore irrelevant. In 1961, Act 187 established the state land use classification system, including the urban, agricultural, and conservation districts. In 1962, the Attorney General opined that single-family dwelling units situated in the agricultural district cannot be sustained if they operated to defeat or frustrate the purposes and intent of the legislature. The Attorney General stated, a single-family dwelling is a place of residence situated on land classified as agricultural, but which is not accessory to or used in connection with a primary agricultural activity. It is in effect the uses of land solely for residential purposes where the land has been designated as agricultural. Clearly, the Land Use Commission cannot allow lands classified as agricultural for residential purposes if in so doing, the essential character of the area is changed from agricultural to urban. To do so would render the district boundaries meaningless and defeat the purpose of Act 187. Notably, various public testimony received in this matter described how steivers have adversely changed the character of the agricultural district with excessive noise, light pollution, inconsiderate large groups of renters, and additional traffic. Steivers are therefore impermissibly injecting urban character and uses into the agricultural district, thereby defeating the purposes of the state land use system. Fourthly, even if the commission somehow determined that the HRS 205 4.5A4 definition of farm dwelling does allow use as a steiver, the counties are empowered to more restrictively regulate farm dwellings such that they may not be used as steivers. HRS 205 5B states, within agricultural districts, uses compatible to the activities described in section 205.2 as determined by the commission shall be permitted, provided that accessory agricultural uses and services described in sections 205.2 and 205 4.5 may be further defined by each county by zoning ordinance. Therefore, even if the farm dwelling definition is found to not prohibit their use as steivers, the county's ordinance prohibiting the use of farm dwellings as steivers has the overriding full force and effect of law. So clearly, 1, a steiver is an incompatible use of a farm dwelling. 2, a steiver is not a permitted use as a farm dwelling under HRS 205. 3, purely residential uses with no connection to agricultural use, such as a steiver use, have never been allowed in the agricultural district. And 4, the counties are empowered to more restrictively regulate farm dwellings to not be used as steivers. Therefore, a farm dwelling cannot be used as a steiver. The commission should not be deterred from this clear and simple determination by certain distractions that have arisen during these proceedings. First, there appear to be issues with the county's ability to enforce farm dwelling use restrictions, which is not uncommon among all the counties or even other jurisdictions charged with enforcing land use restrictions. But the county's ability to enforce is completely irrelevant to the question of whether a farm dwelling may be used as a steiver. The commission need only be focused on the actual land use restriction rather than its enforcement. The county has stated for the record its position that consistent with HRS 205.2D7 and 205 4.5A4, a farm dwelling must be used in connection with agriculture. Secondly, the Rosehill petitioners argue that the issue is not about the farm dwelling and STVR uses, but about the lack of an express prohibition on rentals of 30 days or less within the definition of farm dwelling. This is the red herring. Petitioners are redirecting the commission's attention away from examining the use of the farm dwelling as a steiver to hyper-focus the attention on a narrow and inconsequential detail. An express 30-day rental term prohibition is inconsequential because, again, the statute is a permissible statute, not a prohibitive statute. Petitioners erroneously interpret the statute as not prohibiting steivers as farm dwellings and therefore believe they are allowed. Rather, because steivers are not expressly permitted under the statute, steivers are prohibited. Additionally, petitioners are arguing that the county's stever ordinance has nothing to do with farming, which is absolutely correct. That's because it's a stever ordinance. Yet petitioners are pointing to the stever ordinance to define the uses of the agricultural district when it should look at the ag ordinances and statutes to determine the correct use of a farm dwelling. As controversial and time-consuming these distractions have been, they are extraneous and irrelevant here. The commission must set these distractions aside and focus on whether a farm dwelling may be used as a stever. Finally, Commissioner Wong asks if you have one papaya tree, one donkey, or one horse on your property in the ag district, would that be considered agricultural use for purposes of a farm dwelling? The agricultural use must be commercial and not for personal consumption and use only. So you can have a papaya tree, donkey, or horse, but they must be part of a commercial agricultural use. You can't simply eat your papayas or ride your donkey or horse. This was determined under a Land Use Commission Declaratory Order, DR 83-8, which was made upon the Commission's own motion and stated that in 1983, Senate Bill 993 purported to amend HRS 205 4.5 to permit the raising of crops for both commercial and personal use. Governor George R. Yoshi vetoed the bill as an expression of the state's policy that the agricultural use must be commercial to be a permitted use on lands in the agricultural district. In its ruling, the commission declared that a single-family dwelling can be defined as a farm dwelling only if the dwelling is used in connection with a farm or agricultural activity provides income to the family occupying the dwelling, and that a single-family dwelling which use is accessory to an agricultural activity for personal consumption and use only is not permissible within the agricultural district. I'm sure you asked that question, Commissioner Wong, because it's ridiculous to think we'd allow someone to merely plant a papaya tree to qualify to have a farm dwelling in the agricultural district. It would create a huge loophole through which people could circumvent the land use law to establish a residential dwelling in the agricultural district without legitimate agricultural activity or use. The matter before this commission today is another attempt to create a loophole by petitioners construing the statute to allow a stever use of a farm dwelling with no agricultural connection in the agricultural district. In 1961, the legislature declared that inadequate controls have caused many of Hawaii's limited and valuable lands to be used for purposes that may have a short-term gain to a few, but result in a long-term loss to the income and growth potential of our economy, scattered subdivisions with expensive yet reduced public services, and the shifting of prime agricultural lands into non-revenue producing residential uses. Whether it's one papaya tree, an ag subdivision, or stever, these are all attempts to subvert the spirit and intent of the state land use law for the short-term gain of a few. Like those commissions before you, you have the opportunity and the responsibility to protect the agricultural district by rejecting and invalidating petitioner's loophole and declaring that a farm dwelling may not be used as a stever. And that's my summary. Thank you.
Okay, Ms. Apuna, if I may ask this question, which I pose to the County of Hawaii. If I came to a government official and I own a piece of property within the agricultural district, and I told the government official, I want a permit to allow me to put up a dwelling unit, which I will live in there. But I'm telling you, I'm not going to grow anything, even for private consumption. Okay, there is not going to be any agriculture here Because when I was growing up, I used to go to Hakalau and pick orchids on my uncle's orchid farm. And after that, I want nothing to do with agriculture. So there's going to be absolutely no agriculture. Should the government official issue me the permit to allow me to build my dwelling unit when I've made it absolutely clear I am not going to engage in any agriculture, come hell, high water, or anything else?
No, because that would be in violation of HRS 205 4.5A4 as not having a farm dwelling not in connection with any agricultural use.
Okay, and just so that the record is clear, I had read portions of the declaratory order which was issued in the docket DR 94-17 that was in the matter of the petition of John Godfrey. That was conclusion of law number 5. Let me read it again, and then I will ask you whether or not what I read, which is a quote from the declaratory order, is still an accurate and good statement of the law. And I quote, Chapter 205, Hawaii Revised Statutes, does not authorize residential dwellings as a permissible use within an agricultural use district unless the dwelling is related to an agricultural activity or is a, quote, farm dwelling, close quote. Is that an accurate statement of the current state of the law on that matter?
Yes, I believe it is. It's consistent with the statute and it's consistent with the Attorney General's opinion in 62, as well as the legislature's declaration.
Thank you very much, Ms. Apuna. Thank you, Mr. Chair. No further questions.
Thank you.
Thank you very much, Commissioner Okuda. Commissioners, are there further questions for the county, Mr. Chip Chase, or any of the public witnesses? Commissioner Cabral?
Yes, thank you. Actually, I have a question for the county based on what we've been hearing. The properties, that the Rosehill property that is the subject of this is, and when they got their building permit to build their house, the structure on it, that is less than 5 bedrooms, etc., did they in fact sign, or did the party who built it prior to their ownership sign that your county declaration declaring that it would was going to be permissible under your agricultural rules and regulations?
Aloha, this is April Supernaut. It would take some research to find that out, and we don't know the answer to that question right now.
Okay, but from what we've heard, you would not have issued them a permit on agricultural, a building permit. That's right, that's the other department. Okay, building department. In theory, though, from what you've said, they should not have been issued a building permit unless they were willing to sign that declaratory statement. Is that your understanding?
That is our understanding, but again, we don't issue building permits.
Okay, okay, I understand that. Thank you. Okay.
Is that it, Commissioner Cabral?
Yeah, I'm finished. Thank you.
Okay. Is there anything further, commissioners? Commissioner Okuda, were you? Okay, so you're making the same gesture as you sometimes make to put your virtual hand up. So,
I was just moving around in my chair, Mr. Chair. Sorry.
got it. Yeah. Okay. So if there's, sorry, 20 seconds, just. Okay, thank you. So for all the parties and for the audience who is listening, the attendees in the Zoom meeting, this hearing is in response to 2 requests for a declaratory ruling. As such, the decision of the commission will be made on the written briefs on file and posted to our website. It's not an evidentiary hearing. Any oral presentations made today and any public testimony are taken into account during the Commission's decision-making process. According to our administrative rules, in particular, Section 15-100, within 90 days after receipt of a petition for a declaratory order, the Commission shall either deny the petition in writing, stating the reasons for the denial, issue a declaratory order, or set the matter for hearing as provided in Section 15-103 of the Commission's rules. In addition, Section 15-102 provides that the Commission, for good cause, may refuse to issue a declaratory order by giving specific reasons. Those reasons may include, in other words, the Commission may so refuse under 4 conditions. 1, the question is speculative or purely hypothetical, and does not involve existing facts or facts that cannot be expected to exist in the near future. 2, the petitioner's interest is not of the type that would give the petitioner standing to maintain an action if the petitioner were to seek judicial relief. 3, the issuance of the declaratory order may affect the interests of the Commission in litigation that is pending or may be reasonably expected to arise. Or 4, the matter is not within our jurisdiction. So having heard the final closing arguments of the petitioners, we will now enter formal deliberations on this matter. I will note for the parties and the public that during our deliberations, I will not entertain any additional input from the parties or the public unless those individuals or entities are specifically requested to do so by me. If called upon, I would then ask that any comments be limited specifically to the questions at hand. Next, now, Commissioners, let me confirm that each of you have reviewed the record and are prepared to deliberate on the subject docket. After I call your name, would you please signify with either an aye or a nay that you are prepared to deliberate on this matter? Commissioner Axon.
Aye.
Commissioner Cabral.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Okuda.
Yes.
Commissioner Wong.
Aye.
Commissioner Chang.
Aye.
And I am also prepared to deliberate on this matter. So, Chair, I've laid out the options. We can decline to rule on this matter, or I can entertain a motion with regard to whether or not farm dwellings, as defined in Chapter 205 Hawaii Revised Statutes, may be used for short-term vacation rentals under Sections 205-2 and 205-4.5, and or whether the rental of farm dwellings for periods of 30 days or less was prohibited in the state agricultural district as of June 4th, 1976 under Chapter 205. Commissioners, what is your pleasure? Commissioner Okuda.
Thank you, Mr. Chair. I would like to make a motion which may deviate slightly from what you laid out, but I believe it still covers what the substance of what you presented.
Okay.
I move that, number 1, the Commission deny without prejudice Petitioner Rosehill's petition for relief. And number 2, the Land Use Commission grant the county's petition for relief. And if there is a second and if there is deliberations, I will go through the reasons why I'm making those motions.
A motion has been made by Commissioner Okuda and Commissioner
Seconded
Cabral.
by Nancy Cabral. I'd like to second that.
Okay. Okay, Commissioners, we have a motion in front of us as stated by Commissioner Okuda. Commissioner Okuda, why don't you go ahead and repeat and clarify the reasons for your supporting your motion.
Thank you very much, Mr. Chair. I believe the record demonstrates that the County of Hawaii has met its burden under the administrative rules and statutes to obtain the relief that it is requesting and the declaratory order that it's requesting. And for the reasons that I will explain, I do not believe that Petitioner Rosehill has met that burden. However, because as I will try to explain a bit without taking up too much time, there are these additional facts which seem to be or may not exist outside of the record. We are confined to reviewing this case and making a decision based on the specific record that's presented and not necessarily representations of things which exist outside. And so, I have made the motion that the denial is without prejudice so that petitioners Rosehill can consider if there's a basis to actually bring additional matters up to the Land Use Commission. But specifically, I do not believe petitioner Rosehills have met the requirements to demonstrate a specific factual situation as required by HAR section 15-15-98A, and that the items or relief and circumstances thereof that petitioners Rosehill were raising demonstrate that the question that they were raising at this point in time and on this record is speculative, hypothetical, and frankly, on this record, we cannot adequately determine whether or not it involves an existing situation or one that can reasonably be expected to occur in the future as required by HAR section 15-15-100A1A. And the reason why, I come to that conclusion just with respect to the initial requirement about whether or not the Rosehill petitioners have met the initial gatekeeping function of being able to raise their issue as a declaratory situation where we can issue a declaratory order is the fact that the statute and the case law make clear, and also prior existing declaratory rulings and orders issued by the Land Use Commission, that the actual use of the property determines whether or not the use is lawful and permissible under the statute. And again, I quoted from the docket order in DR 94-17 in the matter of the petition of John Godfrey, where the Land Use Commission held in conclusion of law number 5, and I quote, Chapter 205, Hawaii Revised Statutes does not authorize residential dwellings as a permissible use within an agricultural use district unless the dwelling is related to an agricultural activity or is a, quote, farm dwelling, close quote. And there's simply not enough facts or evidence presented in this record to allow us to make a declaratory ruling with respect to the matters being raised by petitioner Rosehill's request for relief. And in fact, there is a danger, I believe, that if we attempted to make such a ruling on an incomplete record, the ruling itself may actually lead to unlawful or improper results or consequences. I would also note the fact that the case law and the prior orders of the Land Use Commission make clear that a, quote, farm dwelling, close quote, is a, quote, single family dwelling located on and used in connection with a farm, close quote. And the dwelling is not a farm dwelling and is not permissible on land which is designated agriculture as a farm dwelling if you actually don't have that use. And so the record is simply not sufficient as presented by petitioner Rosehill at this point in time to make that, to give them any type of declaratory relief where that is the standard of what constitutes a farm dwelling. Now, with respect to the ordinance passed by the County of Hawaii, the Hawaii Supreme Court in the Save Sunset Beach Coalition versus City and County of Honolulu case, that's found at 102 Hawaii Reports 465. The Pacific Third citation is 78 Pacific Third, page 1, makes clear that there's basically a dual system of land use regulation when it comes to agriculturally districted property. And basically, the decision makers look at the state requirements and the county requirements. And as the Supreme Court said in the Save Sunset Beach Coalition case, which I believe was referred to as the Obayashi case, and this is found at 102 Hawaii at page 482 or 78 Pacific Third at page 18, and I quote, "Only a more restricted use as between the county zoning and the state land use law, HRS chapter 205, is authorized." And I put in brackets county zoning and state land use law, HRS chapter 205. So there is no prohibition in the case law which would prevent the County of Hawaii in exercising its legislative judgment to issue this ordinance in its discretion and legislative process as authorized by statute and the Hawaii State Constitution in determining further management methods or further management actions to protect, in its view, agricultural land in the County of Hawaii. And I specifically asked the question about what authority there is for the Land Use Commission to second guess a otherwise lawful on its face legislative decision by the County of Hawaii Council. And lacking any real clear authority that allows the Land Use Commission to be the body to essentially second guess the county council, I believe we should decline that opportunity, especially in light of the Hawaii Supreme Court's decision in Sunset Beach Coalition versus City and County of Honolulu. And so for those reasons and much of the discussion that had already taken place and the questions going back and forth, I ask that my motion be granted or supported, meaning that the petition filed by the County of Hawaii be approved and the petition by the ROSEHILL petitioners be denied without prejudice. If I can say one last thing, I do agree with the historic and legal description presented by the Office of Planning about the importance of protecting agricultural land. I believe this decision, if adopted by the Land Use Commission, satisfies the public policy why we must protect agricultural land. It's easy to say we want to be self-sufficient, as the Hawaii Constitution requires government agencies to strive for in this community, but we're not going to have self-sustaining agriculture unless we do the things the legislature requires us as government agencies to protect the actual bona fide agricultural use of agriculturally zoned or agriculturally districted property. Frankly speaking, a resort use of agricultural property, the construction of what I described as a Gary Okuda McMansion, it does not move this community towards agricultural self-sufficiency. It doesn't move us towards protecting our food resources, and it's certainly not consistent with the statute. So for those reasons and other good reasons in the record, I ask that my motion be supported. Thank you.
No problem. Thank you, Commissioner Okuda. I will note and remind the commissioners we have 47 minutes till we have to adjourn for the day. Commissioner Cabral, as the seconder, Commissioner Cabral is on audio but was having some video connectivity issues. Are you prepared to speak to the motion, Commissioner, or we can wait to go to you? You're on mute as well. She was trying to find better location in her house. Commissioner Chang.
Okay. Commissioner Okuda, you had me 10 minutes ago, but I'm not sure. I support the motion to grant the county's petition. What I'm unclear about is, without prejudice, you're going to deny Petitioner ROSEHILL without prejudice. It's unclear to me. What set of facts do you think that they could come forward with that would be within the jurisdiction of the Land Use Commission and not a matter of enforcement by the county? So that's, I'm not real clear about the without prejudice.
Mr. Chair, can I respond?
Please.
I made the motion to deny it without prejudice, more out of an abundance of caution. I don't know what facts they can present at this point in time. And yeah, it's not our responsibility, I think, to force people to present a case, although Mr. Chipchase, very well presented the case. It's just that if there is something which they believe the record, shows something different, I would be willing to listen to it. However, just so that, my point is clear, if this motion is granted, it doesn't mean that a later petition brought by Petitioner ROSEHILL or anyone else can relitigate this issue that has been decided. This, I believe, would be not only res judicata, but it would be a statement of law, which would be precedent that the Land Use Commission would have to follow until reversed, long after we are off the commission. So I don't know whether that helps or not.
Commissioner Chang.
Yeah, and I guess Commissioner Okuda, I guess that's my quandary, is the without prejudice seems to leave open, and there's an expectation that we may come back and revisit, or that Petitioner ROSEHILL may come back and reopen. That's normally how I understand without prejudice, is that they can come back. So that's my only concern.
If I may, at this point, ask Mr. Ordenker, as deeply experienced with our procedures, to clarify that even if the motion was made to simply deny the petition, there's nothing that's going to prevent the petitioners from coming forward with a slightly different petition with additional facts in a little while. Is that correct, Mr. Ordenker?
It's correct, Chair.
Okay, so functionally, while the movant has phrased it as without prejudice, even in my mind, if he had simply phrased it as we're granting the county's petition and denying the ROSEHILL petitioners, it would essentially be without prejudice for them to come back without saying it. That's just how our procedures are.
Yeah, well, Mr. Chair, I didn't mean without prejudice to be an impediment. So I'm willing to, if the second would be willing to, I'm willing to modify my motion to delete the term without prejudice.
Ms. Cabral?
Yes, I'm willing to accept that change.
Okay, so this motion now is simply to grant the county's petition and deny the ROSEHILL petition. Commissioner Cabral, would you like to speak to your second?
Yes, I'm in favor of that motion, and although Commissioner Okuda is so much more elegant and legal, in a very major common sense way. I feel that the intent and the practicality of zoning needs to be enforced, and the use of the land is what is paramount here, and that we need to respect that intent, and therefore I'm willing to second that motion. Thank you.
Thank you, Commissioner Cabral. Commissioners, we are in deliberation. We have a motion before us. Commissioner Giovanni?
Second here. Thank you, Chair. I'm going to vote in favor of the motion, and I thank my fellow commissioners for taking me on a merry-go-round of legal issues that I could never anticipate. But what really brought it all home to me was the testimony today, or the answering of questions today, by Ms. Apuna from OP, who I think summed up her position very well, and it's consistent with the motion that's before us now. Her recommendation is consistent with the motion. I want to thank Ms. Apuna for that presentation of her views today, but I'm in favor of the motion. Thank you.
Thank you, Commissioner Giovanni. Commissioner Cabral, we're picking up your audio. Commissioners, we're in deliberation. Commissioner Chang.
Thank you very much, Mr. Chair. And I, like Commissioner Cabral, Commissioner Okuda was extremely eloquent in summarizing, that the land use commissions, our role in looking at overall land use planning and protecting the integrity of agricultural lands. And this was a very important, in my mind, this is a very important issue. Clearly, the other counties also agreed with that in the sense that we received testimony from all of the other counties. As I think that this demonstrates the desire to have LUC define farm dwelling and the intention of agricultural lands, that there has to be activities that are related to the agricultural, or the farm dwelling has to be related to the agricultural activities. So with that clarification and statement, I am inclined to support this motion. Thank you very much.
Thank you,
and I do want to say, I thank all of the parties for this long process and clarifying and getting us to this point. I think the last 2 hours have been extremely enlightening to clarify the issue. So thank you very much.
Thank you, Commissioner Chang. Commissioners, Wong, Ohigashi, or Axon, do you wish to speak to the motion? No? The chair, I will say that I will support the motion. Yeah, I have a lot of respect, a huge amount of respect for Mr. Chip Chase as an attorney and as a person, and his ability to argue and present cases. I take this vote partly in the context of today's headline, right? We have 355 new COVID cases. We're living in the midst of this pandemic. And sitting on the Land Use Commission is, for me, part of a really core governmental duty to help take care of people and make sure that we're fulfilling our statutes and making sure to interpret our statutes in the way in which they were intended to interpret. And I just have to me, it's very clear that transient vacation rentals are not farm dwelling uses. So I'm pleased to support the county's motion. If there's nothing further, Mr. Ordenker, I'd like you to do a roll call vote of the commission.
Thank you, Mr. Chair. The motion is one, for the commission to deny Petitioner Rosehill's petition for relief and to grant the county's petition for relief. Commissioner Okuda,
Yes.
Commissioner Cabral, Commissioner Cabral,
Yes, my apologies. Yes.
Commissioner Giovanni,
Aye.
Commissioner Axon,
Yes.
Commissioner Ohigashi,
Aye.
Commissioner Chang,
Yes.
Commissioner Wong,
Aye.
Chair Schreier.
Aye.
Thank you, Mr. Chair. And the vote, the motion passes unanimously with 8 affirmative votes.
Okay. The hearings on this matter are concluded. A written order or orders in this combined petition will be forthcoming. Is there any further business, Mr. Ordenker?
No, there is not, Mr. Chair.
Okay. Seeing that there's no further business, I wish everybody well, submit my thanks, and declare this meeting adjourned.